May it please your lordship, my lord. One item is item number 12, my lord. 12, when I think Mr. Chaudhary is item number 14.
Yes.
It is a common case, the interest is same. My lord, there was letter of absence from my side for 2 days because I was nasal, but I have to come up yesterday itself. So, my lord, if I couldn't prepare it honestly, my lord, this is a huge case. So if it is not inconvenient to your lordship and my learned friend, and of course, my Chaudhary, can it be fixed after vacation, my lord? This will take some time.
What is the matter about?
Is a matter is employee, a casual worker in social welfare department, my department.
Water issue.
Water issue
Water
department, water is department.
All right.
And for the
All right, take down Mr. D. Das, learned senior counsel appearing for the writ petitioners in item number
12, my lord.
item number 12.
I mean 14. madam. I mean item number 14.
Case for adjournment of hearing of this matter with a request to post the case again after the upcoming summer vacation, expressing personal difficulty today. Full stop. And since the prayer is not opposed by the learned departmental council as well as the
I put it for all the respondents as additional applicant.
learned departmental council as well as the learned council appearing for the petitioners in the connected matters, the prayer stands allowed. A registry to list these cases for hearing again on 25th of July. 25th of July
Yes, we'll do that.
as fixed items. Yes,
So 12, 13, 14.
yes.
My lord, I am praying for listing this matter, my lord, for motion.
Hmm.
My lord, can it be listed day after tomorrow or on Friday, my lord? Well, it was listed on
Friday,
12,
Friday.
my lord. It was listed on 12. My lord, I was directed to
What
file
is the matter?
regarding Gavura appointment, my lord.
Oh, Friday.
My lord.
Maybe I beg to mention for listing my admission matter,
Hmm.
selection and appointment of Gavura, private respondent,
Hmm.
got selection, but not appointed.
So what do you want?
And any date, this week,
No, after vacation.
my lord.
These are not important matters.
Already selected.
After
but not
vacation,
appointed.
yes,
There
after-
is stay order.
After vacation.
I am praying for listing one admission matter, Lordship. In this case, your Lordship has directed them to file obtain instruction. My Lord, they have already filed an affidavit. What is simple regarding compassionate appointment, Lordship? DLC is going to be held shortly, Lordship. May I pray, Lordship, this matter may come on Friday, Lordship.
Yes, it will come on 9th of June. 9th of June.
May I pray, Lordship? Lordship, I beg to mention for listing of motion matter, Lordship. Matter relates to the selection appointment of the CRPF candidate, Lordship.
Hmm.
So similar matter was listed tomorrow, Lordship. So maybe listed, Lordship, tomorrow.
What is the matter?
But the recruitment of the CRPF personnel of the armed forces, Lordship. The petitioner was applied on the ground of height, although they have requisite height of the petitioner. Tomorrow, most of
Yes.
this.
May I pray for listing on 5, 6, my lord. This matter lead to retirement benefits.
May pleasure, sir. With the consent of the other party, madam, I beg to mention item number 11, madam. But today, Mr. Yukina is for some difficulty, my lord. He could not come to court. madam. So- And
Item 11 on the prayer of learned counsel for the petitioner, hearing of these matters stands adjourned for 4 weeks. Please take on.
May it please your lordship, with the consent of the other side, I beg to mention item number 15 of the daily list, my lord. I am praying for an adjournment, lordship. The conducting counsel, Mr. B. Patrick, is lordship out of station.
With the consent of learned counsel for the respondent, the petitioner's counsel makes a prayer for adjourning the hearing of this case today. In view of the grounds cited by the petitioner's counsel, the prayer is allowed. List this case again after 4 weeks.
God bless.
May I please, your lordship, I beg to mention WPC lordship for withdrawal for tomorrow listing, lordship. May I please, your lordship, I beg to mention for listing lordship, in admission column.
Sorry?
Lordship, I beg to mention for listing lordship in admission column. Lordship, matter is relating to pensionary benefit.
Third week of June. 3rd week of June.
May I please your lordship? Lordship, I beg to mention for listing of a repetition for motion, my lord. The matter pertains to employment of Sahayak and office cum field assistant in the AP region, my lord. Well, we've been working there for 15 to 20 years. and
Friday.
Friday, man.
May it please your lordship. In a particular matter where I'm appealing as a legal aid counsel, my lord, we filed an application for impediment. Conveniently, may I plead the matter be listed
Next week.
of that lordship?
May I please your lordship. Lordship, petitioner is agreed with the inter-unit transfer, your lordship will find the impugn order at page 19, your lordship. And he is transferred to CISF unit oil Duliajan. Operative portion, your lordship will find at page 21. 199 is the serial number. Page 21, your lordship. Montu Boru. From CISF unit OPS non-mati to CISF unit oil Duliajan, your lordship. He has been earmarked for the transfer, your lordship. Lordship, he also filed a representation before the competent authority by incorporating all his grievances and grounds, your lordship. First, your lordship,
Where is the representation?
your lordship will find at page 40, annexuary,
Page?
page 40, your lordship. Annexure, your lordship. Here the grounds cited by him, your lordship, the first, his mother, old ailing mother is completely dependent on him. Your
When
lordship.
was he posted in this place, Nunmati?
He was posted, your lordship will find his detail.
No, you tell me, what is the date?
That is on 1st June of 2019, your lordship, 2019.
So he has completed more than.
He is completed, but the the thing is that his mother is a old ailing mother and he suffered from the brain hemorrhage. Your lordship, may I take your lordship to page 24? Annexure C only, and the operative, the page, your lordship will find at page 31. Page 31, your lordship. Page 31. Final diagnosis, your lordship will find right thalamic bleed with intraventricular extension. And so far the CT brain, the last line, your lordship, in the same page.
So Duliajan, there is a medical college in Dibrugarh also.
It is there, but now her treatment is going on at Rahman Hospital. That is which is nearby to his unit, your lordship.
What do you say?
And apart from that, another aspect is also that his wife is 3 months pregnant and her medical checkup and everything is
People
going
are
on.
moving
at the
around
concerned
with these
doctors and anomalies
These
scan.
are
Everything.
not grounds.
But so far his mother is concerned. He is fully dependent upon him and his father also expired. So at this stage,
Mr. Goswami,
either
what is-
represent-
For 3 years, 11 months, he is in the present place of posting. So as per the notification, circular, my lord, only 3 years is required to be stay in a particular post. And he, prior to issuance of the impugn order, he submitted his difficulty placed before the authority. Authority has looked into everything, my lord. Because the grievance given by the cited by the mother's ailment, the minor children of her his wife. Well, there is a all India, there is a medical hospital.
Minor children is the other matter. You are mixing up.
Sorry.
Here the children is yet to come.
Yet to come. Well, there is a well-established hospital in Duliajan, the oil hospital. He no need to go even for Assam Medical College, Dibrugarh. That cannot be a ground. And that is why, my lord, my respectful submission for this is a routine test why Yellow says knows the he has no enforceable right otherwise. So my respectful submission for your lordships may not entertain this repetition.
Oil hospital is also here at Nunmati, your lordship, but the so far
Mr. Bora can't be helped. These are
treatment
not
is
grounds.
going on. That is in the
Give him 1 month's time.
But in fact, my
and
lord,
in the representation, lordship, he also requested for deferment also. At least for 1 year so that he can settle.
No, how 1 year we are not getting it.
well,
Can you give him a little time?
they have to move out as per the impugn order by 31st. They have to. That is why this matter today. if your
31st of
lordship-
May. 31st of May.
So,
Give him time till 30th June. That's all.
my lord.
That's all. All right, heard. Heard Mr. D. Bora, learned counsel appearing for the writ petitioner. Also heard Mr. U.K. Goswami, learned CVC appearing for the respondent. Full stop. The writ petitioner is serving as CT/GD under the CISF and is presently posted. CISF means Central Industrial Security Force, bracket CISF, and is presently posted in the OPS Nunmati unit. Full stop. He was transferred to the CISF unit at Nunmati, Guwahati, 3 years, 11 months back. Full stop. By the impugned transfer order dated
Dated your receipt 3/5/2023.
3/5/2023, whereby group transfer of CISF constables have been effected, comma, the writ petitioner has been transferred from Nunmati and posted at the CISF unit at Duliajan. Assailing the order of transfer, the writ petitioner has approached this court on the twin grounds that his mother, who had suffered a brain stroke in the year 2021, is undergoing treatment in a specialized hospital at Guwahati. Secondly, his wife is expecting a child. His wife is 3 months pregnant and is expecting a child. Under the circumstances, the petitioner is required to move from Nunmati to Guwahati to Duliajan. The same would not only adversely affect the treatment of his mother, but would also pose undue danger to his wife. Full stop. Hence, the writ petition. Full stop. Mr. Goswami and his CGC, on the other hand, submits that there is a well-equipped hospital at Duliajan, wherein the mother and wife of the petitioner can receive treatment. Full stop. Moreover, contending that the petitioner has completed more than 3 years, 11 months in the present place of posting, Mr. Goswami submits that this is a routine transfer, and if the respondent and routine transfer carried out as per the transfer policy of the CISF, as such, there is no good ground for this court to interfere in the matter. Full stop. After going through the materials available on record, this court finds that the mother of the petitioner did suffer from a brain stroke and is undergoing treatment.
Well, just may I point out, there is he earlier submitted a representation for deferment and cancellation that has been rejected. 2 names are there. The first name is the other petitioner, the second name Montu Boru is there. So that is my instruction.
He is undergoing treatment at the Rahman Hospital Private Limited at Guwahati. Full stop. However, the documents annexed to the writ petition does not indicate as to why the mother of the petitioner cannot be treated in the oil hospital at Duliajan. Full stop. Moreover, the fact that his wife is pregnant is a part of usual. Pregnant is a normal affair in the family life of almost all the employees, and that cannot be a ground for this court to interfere with the transfer order. Full stop. Law is well settled that transfer is incident of service, and the scope for the writ court to exercise with an order of transfer under Article 226 of the Constitution of India is very limited. Full stop. And nothing has been shown by the petitioner's counsel to establish that the transfer order is in violation, has been issued in violation of the policy guidelines or the terms and conditions of service, first of. Moreover, that apart, Mr. Goswami has also produced a copy of the notification dated 29/5/2023 issued by the competent authority, which goes to show that the representation submitted by the petitioner has been considered and rejected. Under the circumstances, I do not find any good ground to interfere with the order of transfer. The writ petition is accordingly dismissed. However, for ends of justice and taking note of the submission made by petitioner's counsel, it is hereby provided that the petitioner shall be allowed time till 30th of June 2023 to join in his new place of posting. Writ petition stands closed.
Lordship, it's also a transfer matter, your lordship.
Is there any policy for? central
Here,
government?
they have indicated the husband, wife, that there's a policy of 2009.
Yes.
Her husband is nearby in the CRP. That is why considering that ground and minor child, competent authority decided not to transfer her out and allow her to remain in the post. That document flag mark, the next page is there.
So,
Next. Allow her to remain in the present place of posting till 31st March 2024. That is indicated in that communication.
so 1 year extension has been granted. Take down, heard Mr. D. Boral and a counsel for the petitioner. Also heard Mr. U.K. Goswami, learned CTC appearing for the respondents. The writ petitioner has approached this court assailing the service order dated 3/5/2023, by means of which she has been transferred from her present posting at the CISF unit, BGTPP, Bongaigaon, and posted at the CISF unit BRPL bracket IOCL bracket close. She was transferred from Bongaigaon to?
First, Bongaigaon to Dibrugarh, lordship.
That has been
Then-
modified and
and-
allow her to remain in the.
One more service order is there, your lordship will find at page 31. As well as 16/2020.
Where is the order of transfer?
The lordship will find the page 31, that is the last order. 16/2023.
She was transferred from BRPL Bongaigaon to.
First to Dibrugarh, your lordship.
Hmm.
Then again, the final destination is given as BGTTP Bongaigaon.
So Bongaigaon to Bongaigaon.
Bongaigaon, actually the BRPL Bongaigaon, that is in the Shirang district. And this so far BGTP Bongaigaon is concerned, that is in the border area. So after the personal interview, that has been.
The transfer and so. Initially to the NEZ/BCPL, Dibrugarh, which was subsequently modified, and the petitioner was posted at BGTPP at Bongaigaon. I go to BRPL Bongaigaon to BGTP. BGTPP. ঠিক আছে? As per order dated 29/5/2023, Mr. Goswami, 23 passed by this court, Mr. Goswami has obtained instruction and has produced a copy of the written instruction dated 9/5/2023. A perusal of the written instruction goes to show that the petitioner has been allowed to continue in her present place of posting at BRPL Bongaigaon until 31/3/2024 in view of the personal difficulties expressed by her. First up, if that be so, the grievance of the petitioner uh, has been redressed by the authorities, since it was the alternative prayer of the petitioner to allow her to continue in the present place for at least 1 year. First up, Mr. Bora has also, Mr. Bora, learned counsel for the petitioner, has also fairly agreed to the said proposition. In view of the above, by retaining a copy of the communication dated 9/5/2023 in the record of this case, this writ petition stands carried.
Highly obliged.
But upon being confronted, he did inform us, my lord, and so we are anyway withdrawing our names, my lord. He is boarding the train tonight. So my lord would kindly fix the matter after after a couple of weeks, my lord, he'll collect the file from us and if he wishes, he will engage some other counsel.
Otherwise, in this petition, even if it is considered that he would have got that extra marks, still he does not make it on merit. Otherwise.
There is another
yes.
problem here. This.
Yes, madam, I know there was some communication sort of a thing, madam.
These are things we cannot ignore completely. So we'll ask him to appear personally. When is he coming?
My lord, he informed me that he is boarding the train today.
Did you tell him?
Tonight,
Did you tell him about this?
yes.
What does he say?
He forwarded me the message.
Ah.
And
But why did he do it? Under whose advice?
my lord, he did it on his own volition, my lord, and he pleaded innocence.
All right, to take down on the prayer of Mr. P. Bhargav, learned counsel for the petitioner, who submits that the process of withdrawal from the brief is at an advanced stage. This matter is directed to be posted again on 19th of June 2023. Mr. R. Majumdar, learned counsel for the respondents, is present
Madam.
on behalf of the state.
Obliged.
My pleasure.
The lady has consented to sit for mediation.
All right. Heard Miss
MSB Bhuya.
B. Bhuya, learned counsel appearing for the writ petitioner. Also heard Mr. K. Sharma, learned counsel appearing for the respondent number 4. Who is for the other respondents? 1, 2, and 3?
I'm appearing for 1, 2, 3. P. Swargari.
Miss P. Swargari, learned counsel, is present on behalf of the respondent numbers 1, 2, and 3. After going through the materials on record and upon hearing the submission made by learned counsel for both the contesting parties, this court was of the view that the issue that the core dispute, core dispute involved in this writ petition is nothing but a matrimonial dispute which can be resolved amicably if the parties are agreeable to go for mediation. Accordingly, by order dated 18/5/2023, the learned counsel for both the parties were asked to obtain instruction as to whether their respective clients are willing to go for mediation. Today, when the matter is called up, Ms. Bhuya, learned counsel for the petitioner, and Mr. K. Sharma, learned counsel for the respondent number 4, have both submitted on the basis of instructions obtained from their respective clients that both the parties are willing to go for mediation. In view of the above, this matter is hereby referred to the Guwahati High Court Mediation Center, since the petitioner is presently posted at
Ujar, my lordship.
Ujar.
Ujar.
Ujar is in which?
Gujarat.
Gujarat.
Yes,
Gujarat.
yes, sir.
And this court is informed that he will be present at Guwahati on
After 21st, my lordship. After 26, my lordship.
But they will issue notice, mediation center will issue notice.
other than Gujarat. The secretary Guwahati High Court Mediation Center to issue notice to both the parties notifying the date of appearance in the matter. Full stop. This writ petition be listed again along with the report of the mediation center or after 2 months, whichever is earlier.
Made with your lordship. Lordship, the PNOD is the main respondent here, but their name is not reflected in the cause list. Only GA Assam is reflected, my lord. We are a formal party.
Third learned counsel for the petitioner. Let this writ petition be listed again after 10 days by reflecting the name of learned SC PNRD Assam in the cause list. Ms. MD Bora learned G Assam is present on behalf of the respondent number 1.
My lord.
Yeah, please, your lordship. My lordship, the government has to file the affidavit, my lordship, which has not been filed, my lordship.
After 2 weeks. In the meantime.
My lordship, the last order, my lordship, kindly reflected, my lordship, sir. 15/5/2023.
Yes. In the meantime, respondents may file.
Obliged.
Obliged. Item 4.
Respondent means, you file IA. You are for the petitioner. No, I am for the government. So we are with you.
Yes, who's for
No,
the?
we are for the respondent here, the respondent 4, and the last date the petitioner was to appear. But we decided to give him a chance because he's not been appearing in previous litigations have been dismissed for non-prosecution. So,
My lord, the similar, in this similar cause of action, they have challenged, this same writ petition has challenged another writ, in another writ petition that was dismissed for non-prosecution. If my lord goes to this page number 42 of this IA. Mamuni Purvi? No. I am going for this Mamuni. Padun.
What is this? What is the issue in the writ petition?
Writ petition, my lord, the writ petitioner has challenged, my lord, the selection of 6 master waiver, my lord. That
Give me the
waive,
writ petition.
in fact, they have filed 2 writ petitions, same cause of action. One was dismissed.
both were dismissed.
No, that was by another writ petitioner. That was another writ petitioner.
No, 1 minute. Please take your seat. So result has been declared and appointments have been made.
Everything is over, my lord. Long back, everything is over. They, in fact, this writ petitioner, he also participated in the my lord process. He did not get through. And my lord, one thing is, he has filed 2 writ petition, the same cause of action. The other writ petition is 2128 of 2020. That was also dismissed.
Where is the order? You have the order?
I have the order, my lord, that is also annexed.
I number 155.
1255, my lord, IA. It is there, my lord.
Filed by selected candidate.
Filed by the selected candidate, 1255, na?
1 to double.
1255, my lord, page number 40.
This has been filed by selected candidates.
No,
This IA 1255.
yes, my lord.
What for praying for dismissal of the connected petition?
My lord, their prayer is that, my lord, similar writ petitions to other writ petitions are filed. One being the same writ petitioner, that both the petitions are dismissed earlier. So,
Where is the order?
my lord, one is in page number 40, my lord. This was filed by the same writ petitioner, my lord, Onkuman Kulta. Page number 40, my lord. The operative portion is 42.
So Onkumani Kalita is one of the petitioners in the present petition.
And another, my lord, that also there is in page number 25, my lord.
Page number 25.
Page number 25. What happened, my lord? Here also another unsuccessful candidate, he filed this petition. Once the government filed their affidavit, my lord, they stopped coming, my lord, appearing in the case. So after a few dates, when they stopped appearing, my lord, the court was bound to dismiss this for non-prosecution. Then again thereafter, he filed a IA. They are also again withdrawn for restoration. The next page, my lord, page number 28, that is they file IA for restoration of the dismissed petition, my lord. That again was withdrawn. The operative party is in page number 32.
So then another writ petition is WPC 1281 of 2020.
My lord.
No. This is
No,
by another-
there is IA, my lord. Another is 1281 of 2020.
that is
That
filed
is
by somebody else.
by another writ petitioner, my lord. Jitumani Basho. The same writ petitioner's writ petition is 2181 of 2020, my lord.
And after the IA was dismissed on withdrawal, then this writ petition has been filed.
Then this one came. Two writ petitions came, my lord, by the same writ petitioner.
Which are the two writ petitions?
One is the current, my lord, present one, and the other is 2181 of 2020. That is in page number 40. That has been dismissed again. And it's dismissed, my lord, on 10/12/21 for non-prosecution. Till today, they haven't filed restoration petition.
So it is the same cause of action.
Same cause of action, identical.
So who is appearing for the applicant in 1255?
I am appearing, Lordship. I am the selected candidate.
And you are the.
I'm the ex officio director, my lord, at the time of selection. In this case, they've listed me by name as a party. So I moved an application for striking off. Since I don't have anything to do with the.
So that is
department.
IA number 1036 of 2023.
Miller.
Acha. But, you are for?
For respondent 10, 11 and 12.
They were, my lord, this is in selection committee, they were
As the expert.
experts, my lord,
In the
who took, my lord, this practical exams.
All right. Take down. Heard Mr. P.N. Chaudhary, learned counsel for the applicant in IA bracket C bracket close number 1036 2023. Also heard Mr. M.K. Hussain, learned counsel for the applicants in IA bracket civil bracket close 1255 of 2023. Mr. R. Dhar, learned standing counsel, handloom and textile department, Assam, has appeared for the official respondents, whereas Mr.
K.H. Khondokar,
K. H. Khondokar
respondent 10, 11 and 12.
is present on behalf of respondent numbers 10, 11 and 12 in the writ petition, who are the experts in the selection committee. Full stop. Both these interlocutory applications arise out of WPC number 3989 of 2020, wherein the two writ petitioners, namely Onkumoni Kalita and Sri Onkumoni Kalita and Sri Bipul Chandra Bishop, have assailed the procedure adopted for selection and appointment of as many as 6 candidates in the Directorate of Handloom and Textile Department, Government of Assam, in the post of weaver. Is it weaver?
Master weaver.
In the post of master weaver. The selection process was held in the year 2019,
19.
whereafter the select list of successful candidates were also notified on 10/9/2020, pursuant whereto all the 6 selected candidates have been appointed. Full stop. These 6 selected candidates, who are the respondent numbers 10 to 16. Why 10 to 18?
13 to 18, sir.
13 to 18
13 to 18.
in the writ petition are the applicants in IA civil number 1255 of 2023. Full stop. The respondent number 5, respondent number 4, Srimati Kavita Deka, was the Director of Handloom and Textile Department, Government of Assam, at the relevant point of time, and she has been included in her personal capacity in the writ petition. As such, the respondent number 4 as applicant has filed IA civil number 1036 of 2023 with a prayer to strike off her name from the arrow of parties. Full stop.
She's already filed affidavit in opposition when she was director in the other WPCs.
Yes.
Full stop.
She filed.
Full stop. Full stop. Mr. Dhar, learned departmental counsel, has. No, you write. The learned counsel for the writ petitioner is absent today. Full stop. I find from the record that the petitioner's counsel was absent even on the previous date, that is 15/5/2023, when the matter was listed before this court, as a result of which the proceedings had to be adjourned so as to give him an opportunity to argue the matter. Mr. Dhar, learned departmental counsel, has also invited the attention of this court to the fact that one of the petitioners, namely Sri Jitumoni Bosho. Jitumoni Bosho is a petitioner here.
Yes, one of the petitioners.
Had earlier,
No, my lord, here Onkumoni Bosho is a Onkumoni Kolita.
Vipul Chandra Bosho.
Here Onkumoni Kolita and Bipul Chandra Bosho.
this IA 1285 of 2020, that was
By Jitumani Vaishya.
By Jitumoni Bosho. That is another writ petitioner, my lord.
Acha, has invited the attention of this court
Page number 40, my lord.
to the documents annexed to the interlocutory applications to show that earlier, one Jitu Moni Boisho, another unsuccessful candidate, had approached this court by filing WPC number 1281/2020 on the same cause of action. First of, the aforesaid writ petition was dismissed for non-prosecution, and even the application filed by the said petitioner for restoration of the writ petition was dismissed on withdrawal. Notwithstanding the same, the present petitioners, along with one present petitioners,
Present petitioners with
along with one Bidut Mani Boisho, had instituted WPC number 2181/2020 on the same cause of action, which writ petition was dismissed for non-prosecution by the learned single judge by order dated 10/12/2021. Full stop. Without seeking restoration of the aforesaid writ petition, the petitioners have once again approached this court by filing WPC number 3989/2020. Full stop. Mr. Dhar therefore submits that apart from the fact that there is no merit in the writ petition, the same is not maintainable in law as well as in the facts and circumstances of the case. Full stop. Mr. P.N. Chaudhary, learned counsel for the applicant in IA 1036/2023 submits that his client has filed an affidavit in the other writ petition,
WPC 1281/20
being WPC 1281/2020,
on 13th of May.
bringing all the facts on record, and therefore there is no justifiable ground for the petitioners to implead her in personal capacity in the present writ petition. Full stop. Mr. Hussain, learned counsel for the applicant in IA Civil 1255/2023 submits that the writ petition is barred by law, and therefore the same is liable to be dismissed. Full stop. Similar is the stand of Mr. Khandakar, learned counsel appearing for the respond numbers 8, 9, and 10.
10, 11, and
10, 11, and 12 in the writ petition. After going through the materials on record, I find that an earlier writ petition being WPC number 1281
and 2181.
2181/2020 referred by the two writ petitioners along with another unsuccessful candidate on the same cause of action and with similar nature of prayer was dismissed by this court. Full stop. Notwithstanding the same, the subsequent writ petition being WPC number 3989/2020 has been filed without seeking restoration of the earlier writ petition. Full stop. Since the earlier petition filed by the writ petitioners has been dismissed by this court, a second writ petition on the same cause of action was clearly not maintainable in the eye of law. In view of the above, the prayer made in IS Civil number 1255/2023 is hereby allowed. Writ petition being WPC number 3989/2020 is hereby dismissed as not maintainable in the eye of law. IS stands disposed of. Then you write, in view of the IA number, accordingly, IA number so and so and so and so stand disposed of.
Give you like.
Lordship. So I just met Mr. Chaudhary. He said, please start, he will join. I think his matter is on his legs. Lordship had last time raised a few queries. And on that, Lordship was broadly, Lordship was looking at the aspect of the misconduct. and the interplay, whether that event of misconduct would it matter in terms of the entry prior to the service or the entry after into the service. That, if I've understood correctly, was what Lordship's contention was, because the argument was on Article 311, Article 311, and the issue of misconduct, and Mr. Chaudhary had raised the point of live nexus between the two. Now, Lordship, if Lordship deems it fit, I can take 5 minutes to just recap what is my case about. Then what I'm proposing, Lordship, is pursuant to last time's what flowed from this honorable bench, is make a few submissions. And then, Lordship, I had already shown para 46 onwards of the coordinate bench judgment. We had gone through that. But if Lordship would permit, I'll show a few more paragraphs to basically point out three things. A, there were three kinds of discharge orders in the APSC batch. There was a simpliciter discharge, and this argument had been taken that a simpliciter discharge order may also carry with it a punitive aspect. So there was that kind of simpliciter discharge. There is a rather detailed discharge. And then there is one which may qualify or be termed as a stigmatic discharge. So the learned single judge considered all three. Additionally, 2 or 3 paragraphs where the argument that is being taken by the learned senior advocate has already been taken and considered. And what was the counter argument of the state? And finally, what does the learned single judge hold? So that is one aspect. Second, Lordship, we found an interesting case in this interim period. Many of the cases that are being raised in support of the arguments of the petitioner herein have been considered and duly adjudicated upon. Now, while searching for some cases, we came across a 3-judge bench judgment of the Honorable Supreme Court of Justice Khare. And this one is a 2004 judgment, but very interesting, Lordship. While the facts may not match us, but the principle would become important. This was the case of a person who was discharged 27 years after being in service. And in his case, he had entered the service on the basis of a forged caste certificate. And he went on to get promotions. And when he was dismissed from service, not discharged, I beg your pardon, dismissed, the question also of his pecuniary benefits in terms of retirement and other things was raised. Now, while these facts are different, the court has specifically held that if your entry was not bona fide to that effect, you cannot claim any benefit or protection. There is no equity, because in effect, your public interest is harmed by you prevented a bona fide entry of another officer, and public interest is not served. So all of that has also been considered, and there are some important findings in that, which I shall, as an additional judgment, bring it before Lordship. So Lordship, the crux of our case is 6-7 main points. One is, Lordship, which is the first point, is that it's covered squarely by the judgment of 2020 by the coordinate bench. Second, Lordship, the petitioner has no right to continue in office. The facts are identical to the others who have been dismissed as upheld by this court, no stay by the division bench where the appeal is pending. Therefore, Lordship, the event, which I will respectfully argue, Lordship, is that has to be considered is the tainted entry. That is the critical event. That is the determinative point. His entry into service being tainted, which is what the coordinate bench holds, which is what also Justice Khare's judgment will additionally bolster that point. Second, Lordship, a fraudulent entry into service. Fraud unravels everything. He cannot claim any benefit from 2 aspects. A, the protection under 311, because this is not misconduct after a bona fide entry. This is not misconduct during discharge of his official functions. This is misconduct or fraud to enter into the service. So he can't claim the protection of the service rules for something, an event, which is tainted prior to his entry or to get into his entry.
Madam, you take your seat. Let him argue. Yes.
So,
You can understand
Lordship,
her.
able, I know, Lordship, able colleagues.
No, that's very good. But when
And sometimes,
two-
Lordship, we allow our
when
colleagues
two
to.
councils are standing on the same side, it becomes a little
Distracting.
intimidating for this.
Yes, Lordship, I know. So,
Nothing against you.
no, of course, not
You
at
are
all.
entitled to, yes.
Then, Lordship. So I was talking of the entry being tainted. So the determinative factor is there.
Hmm.
The second, so he can't claim the protection of the service rules. He can't claim the protection of 311 because the entry itself is not bona fide and it's not during discharge of his duties. Second, Lordship, he can't even claim, respectfully, I would say, humbly, that he can't claim equity in the writ jurisdiction of this court, invoking the writ jurisdiction, because what he is standing before is personal interest, not public interest, which is the
Right, Mr. Kohli, just a quick recapitulation of the facts.
Lord, may I, Lordship?
Yes, yes.
So,
please.
Lordship,
Yes.
essentially,
Hmm.
he is, take out my other folder, the down one, the higher thing. So, Lordship, I'll in fact take it through his petition itself instead of my reply, it'll be easier. Very brief facts, Lordship.
Yes.
Which is, Lordship,
Hmm.
his appointment order is of 26/2/2016, which is on page 58 of the petition. 26/2/2016. 26/2/2016, which is Annexure A6, page 58. And Lordship, the only thing to be noted is the word temporary
Yes.
at page 56. 58, I beg your pardon. So Lordship may note it, which is in the first paragraph, third last line. He's appointed as an agricultural development officer, which is ADO, temporary. And right, Lordship, and the petitioner's name is at serial number 65, next page. Then Lordship may come to Annexure 11 at page 69, that is the FIR. The FIR or the complaint is of the date of 17th of August 2017. And on page 69, Lordship, second last line, his name features, his roll number, and a question on his marks. That's page 69, Lordship. Has Lordship found that?
Yes, yes.
And Lordship, the allegation is he's about 10 lakhs or something, 15 lakhs. Then Lordship may come to page 75 is the bail order.
So what was the complaint in the FIR?
So Lordship, it says from the third line, basically this is someone who says, I was a candidate for the post of agricultural development officer.
Hmm.
He says, I appeared for the viva voce. And his basic argument, Lordship, is that Mrigen Haloi, the petitioner herein, made it. And there is a discrepancy in the marks. Now, Lordship may pause for a minute. 4 or 5 things happened, Lordship, in the APSC, just to assist Lordship on it. Unfortunate, but then also the courts, the government courts, everyone have worked on it. Lordship, there were 3, 4. The modus operandi was very easy. The then chairman, he had a set of people who were full-time touts for him in a sense, and which I will be raising that he's claiming parity with those people, Pater and others. These touts, Lordship, are approaching candidates and basically asking them to pay money and ensure their entry into the APSC. And different rate cards were there for ACS, APS, etc. He's an agricultural development officer. It went as high as what we've gathered.
Was it a printed card or?
Lordship, well, the price was very structured because 35 lakhs was also being paid. And it's come as low agricultural development officer is about 10-15 lakhs. I mean, I'm sorry to say. And Lordship, he had paid 10 lakhs in his case, the petitioner.
Petitioner.
We have raised that, Lordship, on page 20 of our reply. So it's part of the reply.
He is admitted.
Lordship, that's what the investigation's point. Now, Lordship, there are two parts. What my guess also is, maybe not, and subject to correction. My colleague is there from there. So, Lordship, now there are two sets of issues here. Lordship, my guess is, if X paid 35 lakhs, he entered into a deal. And this is not a submission, I'm just trying to point out the modus operandi. He entered into a deal with other fellows, tum bhi aa jao, so that he could recover his money, which becomes like a Ponzi scheme. Now, eventually what happened is, what the system was, one has to complement the enormity of the approach. The system was Mr. Paul's brother owned a printing press, who's even today absconding. So what was happening is, one who paid the amount got an opportunity to rewrite the examination after the examination. So the answer sheets were published in Mr. Paul's brother's press. Then the originals were taken out of the strong room. The answers were rewritten and somebody initialed it as an invigilator. It went back. So it was a bona fide entry in the sense now the answers were up to date. In other cases, there was tampering of marks. You change the marks. They were overwriting, things like that. This exploded in Dibrugarh when a lady approached the police to say, I've been approached by a tout and others, and it should be investigated. The Dibrugarh FIR was the starting point. Eventually, there was a Bhangagarh FIR. The Bhangagarh FIR came out at a point when default bail almost happened for Mr. Paul. And then in Bhangagarh, he was arrested and he stayed incarcerated for almost 6 years. Till recently, he has been released on bail. Supreme Court on 3 occasions rejected the appeals. Now, when the investigation took place, it was a thorough investigation, including a forensic report that identified that this was not the invigilator's signatures. These were not the original papers that went out, and that became the foundation for all the whatever followed. An argument was taken that a police report cannot be based upon, because they may be later on held innocent, in which then a series of judgments, which is how this court looked at it. There's Krishna Yadav, which is a very, very important judgment, Lordship. And then in Krishna Yadav, it was held that we should even disgorge them of the benefits they have taken from the government, but we won't. Now, broadly, the Supreme Court cases came into 2 buckets. Because, Bihar has taken place, Punjab has taken place, which is the Joginder Pal, etc. judgments. The law basically crystallized into 2 aspects. Aspect 1 was, if you cannot identify the tainted and the cheating or the malpractice is so wide, you scrap the exam. The other part was, which is the evolution of it, is don't scrap, because there are people who have bona fide, gone ahead, made efforts. You then then age factor comes in. So the second is, if you can segregate the chaff from the grain, then you only take action qua the tainted. This is the final law that has been laid down. And that's happened whether for teachers.
So on the facts, is that all? Anything else to be
Just
said?
2-3 things more. I'm coming to that.
Yes.
Just 2-3 things.
Yes.
He was, Lordship, named in the 4th supplementary charge sheet, dated 4th July 2019. And his role has been discussed also. That is, Lordship, mentioned on page 20 and 21 of my reply. I just want Lordship to note it. Page 20-21 of my reply. And at 275 of my reply is the annexure where his role is given. I'm just reading that 3 lines out. That during investigation, arrested accused Miguel Haloy, so-and-so, evidence has been collected. And that whole thing is given on page 21-22. So page 20, 21, 22 of my reply, Lordship, is about his role. From para 40.
Just a minute. Where is the reply? It's not there in the report. Check it once.
Lordship, this indulgence we very rarely find except in a final hearing in the Supreme Court of a patient hearing in which you can deal with everything in detail.
No, but for Northeast, Supreme Court is very far off.
Yes,
People-
Lordship, and
people
that
should
is
get
why,
a chance to place their case.
Lordship, that is why also the high courts got founded. Though I must say, my personal view has been that some of the high courts don't have enough work. So I'm not sure whether it has worked in all cases. That's been mine. And I also hold a view that though L. Chandra Kumar kept up the tribunals and all that came up, I believe that the workload of the high courts haven't really decreased necessarily because of the formation of tribunals. Because in several cases, they all do come up as an appeal to the high court and the high court is adjudicating on it, especially in service law.
Same way the arbitration is not working out. Ultimately, it comes to the court.
It's coming down to the court, Lordship. So, I mean, so I belong to the conservative school that says increase the amount of benches of courts and, expand it more because ultimately people want to come to the court.
All right, so you refer to
Page 20.
Para 20 and 21.
No, Lordship, page 20, para 43 of my counter. Page 20, para 43 onwards. I won't read it fully. I'll just point Lordship out to it.
Yes.
43, 44, page 21.
Hmm.
And then at the bottom of page 21, para 48 is about the fourth supplementary charge sheet dated 4th of July. And then the crux of it is reproduced here, but the details are at page 275. So coming back to his petition, Lordship, FIR was on page 69, Lordship.
Yes.
The complaint, which is 17th of August. And Lordship may come to 75 is the bail order. He was arrested, suspended, all that happened. 26th of July 2019 is his bail order, Lordship. In this, on page 81, Lordship, on page 81, I had pointed out, Lordship, the 3 paragraphs. The top paragraph, I have gone through the order dated. Then Lordship may come to the 3rd paragraph, accused petitioner Mrigen Holloway. This is important, Lordship. Who is a beneficiary of the illegal racket, in my view, cannot be equated with the main kingpins. So they were comparing it with the kingpins. Now, Lordship, my point on this paragraph was this is a finding of this honorable court which has not been challenged. Page 81.
This is a finding of this court or special judge?
Special, I stand corrected. I stand corrected. Lordship, of the special judge which hasn't been challenged in this court. They haven't appealed. So this finding has to be noted of. Next paragraph, he is released on bail and Lordship may come to page 112. Which was his reply to the show cause notice.
Yes.
And at 114 is what I wish to show is para 4.
Yes.
So basically, Lordship, this is important because in para 4, he is claiming in point A, making a comparison on the last line of para 4A is Nabakanta Patil and his reinstatement. And my argument was that A, Nabakanta Patil was a permanent employee whose entry is not tainted. He is not a beneficiary of a scam. He was a tout. So you can't seek the Article 14 argument, which is on that paragraph here. Para 4A and B.
So now, what is the position now? He is in jail or he is out?
No, Lordship, he's out. He was on show cause notice. Basically, Lordship, he's an exceptional case. Why I call it exceptional, there's an exception. For miraculous reasons, he remained hidden away while the rest of the batch was being prosecuted, even though his case kept coming up in the High Court. And he eventually invoked Ajay Chaudhary. So say you have issued a show cause notice to me, suspension, you must within 3 months take action against me, etc. And the department went in and did so. It is at this stage that the department realized that he is one of the accused. I mean, two departments didn't talk to each other, whatever be the reason, or malafide, whatever. And then they brought the matter before me in Delhi. We took then a legal opinion also further. We studied the matter and we said the state is obligated to act under Article 14 for a similarly placed person who's temporary employee, and we should dismiss him. And he has challenged that dismissal. So I have just two more things to show, then this gets out. Page 115, Lordship. He has in 115B given the example of Sayyid Musharraf Hussain. Again, Lordship, that was an APSC employee. 4B on para 100 on page 115, Lordship. Then, Lordship, which is important, is C, which is these are the grounds that we have assailed. That the fact that considering the fact that I'm a government servant. Has Lordship seen that? Para C. Now, Lordship, he's a probationer temporary employee. Second, he completely glosses over everything and he's making comparisons with permanent employees whose entry is not questionable. And last, Lordship, in para 5, what he says, that keep it in abeyance. So instead of coming to the court, and this honorable court gave him the indulgence that in Ajay Chaudhary and all, considering it should be finished on an early date. He now in his reply essentially saying, keep it in abeyance till the criminal case is over. And the impugned discharge is at 121. This is the only facts. And therefore, Lordship, he is discharged under Rule 21. That is at page 23 of my counter, Lordship. I am now on my counter only, Lordship. There are 5-6 legs of my argument.
Yes.
The first is that the event which has to be considered and the determinative factor is the point of entry. I've already argued that. The second is fraud unravels everything. His entry is fraudulent. 3, the state actually is obligated under Article 14 to act equally or in an identical manner to someone who's equally or identically placed, as is he. Same batch, same facts, similar FIR, Dibrugarh, Bhangagarh, etc. Fourth, this is a job for public office. It is paramount to establish public trust in the one who occupies a public office. 5, there is no argument of equity for one who's approached the court with unclean hands. You can't invoke the writ jurisdiction for personal interest at the cost of public interest. Next, the rules of service. The rules of service and the protection of 311 will apply only in a bona fide entry into service, not a fraudulent entry.
Right. So that you are relying on that previous judgment.
Yes. And Lordship, let me show then 3-4 things in the coordinate bench's judgment, because I won't read the findings. I've already read it. And I'll show Lordship that 3-judge bench. So Lordship may come for a
But
moment.
before that, where is this Assam Agriculture Service Rule 1980?
Lordship.
Is it there in the manual?
We gave a copy, but Lordship, page 23, we have reproduced it in our reply.
Page 23. Yeah, but let us see. Is it there? The rules, citations, definitions, where are those?
At page 22 of the repetition, please quote it now.
We both have quoted it, Lordship.
Page 22 of the
Yes.
The Lordship, I am requesting Lordship to come to the judgment of the coordinate bench. In my reply, it starts at page 55. But the operative part, Lordship, you can come is to 39, page 39, Lordship, where the judgment starts. And then, it's page 39, or it will be internal page of the judgment is page 46.
Yes.
I am, Lordship, just glossing through it and coming to page, internal page, Lordship, 52 or 44A. Para 5.
Yes.
I am merely showing, Lordship, in para 5 on these next 2-3 pages, the 3 types of discharge orders. So the one on page 44A is rather detailed. On the next page is the simpliciter discharge. And again, another detailed one. So majority got a simpliciter discharge, which is on page 45, which was argued by the learned senior, is innocuously worded. He uses the term innocuously worded. And then, Lordship, on 45, 46 is the very detailed one. So this argument of it being a stigmatic order was argued on this. Now on page 47, Lordship, para 7 is what the learned senior had argued there. The thrust of Mr. K.N. Chaudhary's submission is that if on the attending facts and circumstances, the impugned order of discharge is seen to be based on alleged misconduct, or if a live connection or nexus is seen to exist between the allegations of misconduct and discharge, then the same, even if couched in a language which may not appear to be stigmatic, would amount to punishment for which a departmental inquiry would be imperative. So this was argued. Lordship, on page 49, para 10. Was the list of judgments. Was the list of judgments. Now, Lordship, in this, Khatri, Palak Modi, all have been considered. But Lordship, the first one being Parshottam Lal Dhingra, there is one sentence which I think is very, very critical and actually helps us, though it's relied upon by the other side. I'll come to that later. Then, Lordship, at page 64, para 30, Lordship. Was the state's arguments. Internal page 72, Lordship, of the judgment.
Yes.
I'll read it for a minute. I'll take your Lordship's indulgence. The state respondents, represented by so-and-so, learned senior counsel, assisted by so-and-so, opens his arguments by saying that notwithstanding any provision in the relevant service rules, the General Clauses Act 1897 abundantly provides that if there is a power to appoint, such power shall also include the power to suspend or dismiss. Having struck this opening note, it is also argued that where a selection process is actuated by fraud, appointments made would be void ab initio on satisfaction that may be derived by the authority based on cogent materials. In the case in hand as submitted, the appointments of the petitioners were not validly made. Their appointments are tainted with the element of fraud, and in fact, as against each of the petitioners, criminal prosecution is on. The vital determination is to be made by the court in the backdrop of the foundational facts involving the petitioners is whether the state action was bona fide on having discharged the petitioners from service. Question raised is, was it not obligatory on the part of the state to take the impugned action for maintaining sanctity and for reposing faith in the system and public officers in relation to the affairs of the state government, and whether in the attending foundational facts was there any other option available to the state? Further, if the relief prayed for in the writ petitions affects public interest, whether prayers so made can be entertained. On the arguments advanced by the petitioners on the police report being the foundation and not the motive, it is submitted that the same are without relevance and do not come into play in this present case, as fraud in the process of selection of the petitioners finds demonstrated at the threshold itself. May I continue, Lordship? It is argued that the decision taken by the state respondents is entirely in conformity with law, and the action so impugned is in the realm of discharge simpliciter when no adverse civil consequences are involved. It is not a case of discharge on alleged misconduct after appointment and during the probationary period, but on discovery of predominant fraud at the point of entry into service. Therefore, according to Mr. Singh, no determination of the question as to whether the impugned action involves motive or foundation vis-a-vis the police report is warranted. On the arguments advanced on behalf of the petitioners that a mere perusal of the discharge orders would show that stigma is all pervasive, thus bringing in the punitive element, so-and-so contends that such argument would be available only in case where there was a valid appointments, which is not so in the cases at hand. Further contention is that the discharge on the basis of police report is valid, and the same have found approval in decisions rendered by the Supreme Court. Also, because of the foundational facts, the petitioners are clearly an identifiable and segregated class of persons whose appointments are tainted. It is not a case of individual enmity, nor any element of bias exists that may be attributable to the action of the state respondents. Para 41, page 75, Lordship, what the court holds. The very first two sentences. In a nutshell, the contentions on behalf of the petitioners are basically that the orders of discharge are founded on alleged misconduct, which can be traced to the investigation and report of the Dibrugarh police. In other words, a live connection exists between the allegations of misconduct and discharge. Besides, stigma is writ large in the orders, so much so that it casts aspersions on integrity and clearly demonstrates that the same has been issued by way of a punishment. And then paragraph 46 onwards is the holding, Lordship. I can take Lordship through that, but
Yes.
that paragraph 46 is at page 87. Internal page 87 of the judgment or 79. It goes up to paragraph 56, the next 6-7 pages. May I read, Lordship?
No, I've seen it.
Yes,
Parts
Lordship.
have been handled.
So let me then show Lordship a judgment. First one sentence from Parshottam Lal Dhingra.
Mhm.
I'll just read it. It's a single
So
sentence.
the petitioners here, they were also in probation, on
Yes, Lordship.
provision.
Yes, Lordship. So, Lordship, Lordship, basically, as I said, there were 3 types of discharge orders. So even though in 3 or 4 cases, there was what may be termed as a stigmatic order, Lordship, before the learned single judge, the determinative factor was the point of entry into the service and the nature of entry into the service. So, Lordship, just one sentence I'm pointing out in that famous judgment of Parshottam Lal Dhingra, which is 1958, Lordship, 5 judge. I'll just read because it's only a single sentence, Lordship.
For a copy?
We have a copy. We'll give a copy. We have a copy. Acha, Lordship is there relied upon. I think they gave a copy.
Achha.
So I went through it again when they gave it.
Purushottam
Lal Dhingra. Citation is, I'll tell you, 1958 SCR 828.
It must be there.
1958 SCR 828 or AIR 1958 SC 36. It's para 26, one sentence.
That's the oldest first judgment on this. All right, you please read slowly.
So Lordship, the two judgments that are very important, one is Palak Modi, which also was, and I pointed out in the findings, Palak Modi has been dealt, but Palak Modi was a bank officer, Lordship, and there were two stages. So her sort of confirmation time was the examination on which the questions had come. So that was being distinguished also by the learned single judge. But there, the basis of entry into the service was not challenged. So I'm reading one sentence, Lordship. I'm happily leave behind my copy. So Lordship, para 26 says, one test for determining whether the termination of the service of a government servant, by the way, bona fide entry, is by way of punishment is to ascertain whether the servant, but for such termination, had a right to hold the post. You have to have a right to hold the post before anything happens. If he had a right to the post, as in the three cases here and above mentioned, the termination of the service will by itself be a punishment and he will be entitled to the protection of Article 311. Lordship may keep my copy. I'm so obliged. I'm sorry I didn't have an extra copy. No problem. So,
Please mark the paragraph. It's
Ma'am,
you read from paragraph?
26. I'll give it to madam.
Hmm.
Just the first two sentences.
Yes.
Then Lordship, I'm coming to Justice Khare's judgment, Lordship. This is 2004. 2004. 2 SCC. I'm giving a copy. 105.
Yes.
2004, 2 SCC, 105. This is 3-judge Lordship. We'll go to para 109, Lordship. Page 109. It starts internal page, Lordship.
Yes.
Para 2, then turn the page to para 4, Lordship. I found this fascinating because this was the first case. Subsequently, we found we haven't used it actually in our arguments.
The author is Justice Bhan.
Yes, Lordship. And Justice Lakshmanan, 3 of them. Justice Khare, but authored by Justice Bhan.
Yes.
So, para 4, in the school record, the caste of Mr. So-and-so, herein referred to as the appellant, was recorded as so-and-so, Veduvar Pillai. His father was one Radhakrishnan Pillai. He was a Nayar by caste. His mother's caste was Veduvar Pillai, Nayar, as well as Veduvar Pillai as are forward castes. The caste of his brother and other 2 sisters in the school record was also recorded as belonging to forward caste. The appellant obtained a community certificate in 1969 from the Tehsildar, Ambalapura, stating that he was a member of the Vettuvan community. On the basis of this certificate, he was able to get an appointment as assistant in the Legislative Secretariat in the year 1973 against a post reserved for SC. In the year 1977, he was selected as direct recruit to the post of DSP, Deputy Superintendent of Police, against a seat reserved for scheduled caste on the basis of caste certificate obtained by him. He was subsequently promoted and included into the cadre of the IPS. The government of Kerala, on the basis of a complaint received, ordered a full-fledged anthropological inquiry into the caste status of the appellant. It was alleged that the appellant did not belong to the scheduled caste and had usurped the post meant for the scheduled caste. That's the facts. Next page, Lordship, para 5. Pursuant to the judgment of this court in Kumari Madhuri Patil versus the Additional Commissioner Tribal Development, the government of Kerala constituted a scrutiny committee by notification of 1995. The inquiry into the caste certificate was referred to by the said scrutiny committee. The appellant was duly notified by the said scrutiny committee. Initially, the appellant challenged the authority of the scrutiny committee before the High Court, but subsequently participated in the proceedings and entered appearance through counsel and submitted the documentary evidence in the support of his claim of being a scheduled caste before the committee. The appellant submitted 117 documents. The scrutiny committee, by an order dated 1995, rejected the claim of the appellant in a well-considered and elaborate order. The appellant challenged the order of the scrutiny committee in the Kerala High Court. Next, paragraph 6. Thereafter, the appellant filed OA so-and-so before the CAT, Ernakulam bench, seeking direction against the respondents not to terminate the service of the appellant based on the proceedings of the scrutiny committee, and also not to terminate the service without satisfying the conditions laid down in Article 311 of the Constitution. So the facts are a little different, but for full disclosure, I'm taking Lordship through it. Para 12, Lordship.
Yes.
Article 311 provides that a member of the civil service of the union or a state shall not be dismissed or removed by any authority subordinate to that by which he was appointed. That the employee shall not be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and has been given a reasonable opportunity of being heard in respect of those charges. In exercise of the power conferred by subsection 1 of section 3 of the All India Services Act 1951, the central government, in consultation with the governments of the state concerned, framed the All India Services Discipline and Appeal Rules 1969. These rules lay down the detailed procedures as to the manner in which the action is required to be taken against a delinquent public servant. Relying upon Article 311 and provisions of the rules, it was contended by Shri Ranjit Kumar, learned senior counsel, who was eventually SG Lordship, Solicitor General, for the appellant, that the service of the appellant could not be terminated without following the procedure laid down therein. Then para 13 becomes important. We do not find any substance in this submission. The misconduct alleged against the appellant is that he entered the service against a reserved post meant for the scheduled caste, scheduled tribe on the basis of a false caste certificate. While appointing the appellant as Deputy Superintendent of Police in the year 1977, he was considered as belonging to the scheduled caste. This was found to be wrong and his appointment is to be treated as cancelled. This action has not been taken not for any misconduct of the appellant during his tenure as a civil servant, but on the finding that he does not belong to the scheduled caste as claimed by him before his appointment to the post. Lordship, we may go down to placitum F. Due opportunity was given, the sentence. Has Lordship got that?
Yes.
Due opportunity was given to the appellant to put forth his point of view and defend himself. The issuance of a fresh notice under the rules for proving the same misconduct, which has already been examined by an independent body constituted under the direction of this court, the decision of which has already been upheld up to this court, would be repetitive as well as futile. The second safeguard in Article 311, that the order of dismissal, removal, and reduction in rank should not be passed by an authority subordinate to that by which he was appointed, has also been met with. The impugned order terminating the services of the appellant has been passed by his appointing. Now, this is not relevant, but I'm reading it only for full disclosure. Para 15, Lordship. Would Lordship wish to get up for a minute, or may I continue?
No, how long?
I am, with this judgment, I will take another 5 minutes. Because this is the what's left.
Where is Mr. Chaudhary? So, but I'll not break it in between. So please inform me. We'll continue for another 5 minutes, then a short break and then. Yes.
Right, Lordship. So I will take only that much time for this judgment. So para 15. Now it's important, Lordship. This apart, the appellant obtained the appointment in the service on the basis that he belonged to a scheduled caste community. When it was found by the scrutiny committee that he did not belong to the scheduled caste community, Lordship may mark, then the very basis of his appointment was taken away. His appointment was no appointment in the eye of law. He cannot claim a right to the post as he had usurped the post meant for a reserved candidate by playing a fraud and producing a false caste certificate. Unless the appellant can lay a claim to the post on the basis of his appointment, he cannot claim the constitutional guarantee given under Article 311 of the Constitution. As he had obtained the appointment on the basis of a false caste certificate, he cannot be considered to be a person who holds a post within the meaning of Article 311 of the Constitution. Findings recorded by the scrutiny committee that the appellant got the appointment on the basis of a false caste certificate has become final. Now, in our case, we have a police report. So therefore, I'm drawing the parallel. While there is a scrutiny committee here, 27 years later, we have a police report, which Krishna Yadav says can be relied upon. There is another judgment, O Chakradhar, which says it can be relied upon. I'm not repeating them because they are judged. They are part of the single judge's judgment, Lordship. Then continuing a little further, we can leave the next sentence, Lordship, 2 sentences, and come just above placitum E, the sentence, the appointment was void from its inception.
That's right.
From placitum E. The appointment was void from its inception. It cannot be said that the same said void appointment would enable the appellant to claim that he was holding a civil post within the meaning of Article 311 of the Constitution. As the appellant had obtained the appointment by playing a fraud, he cannot be allowed to take advantage of his own fraud in entering the service and claim that he was a holder of the post entitled to be dealt with in the terms of Article 311 of the Constitution of India or the rules framed thereunder. Where an appointment into a service has been acquired by practicing fraud or deceit, such an appointment is no appointment in law. In service, and in such a situation, Article 311 of the Constitution is not attracted at all. Para 16. In Ishwar Dayal Saha versus State of Bihar, the division bench of the Patna High Court examined, this is also a very good judgment, Lordship, examined the point as to whether a person who obtained the appointment on the basis of a false caste certificate was entitled to the protection of Article 311 of the Constitution. In the said case, the employee had obtained a appointment by producing a caste certificate that he belonged to a scheduled caste community, which later on was found to be false. His appointment was cancelled. It was contended by the employee that the cancellation of his appointment amounted to removal from service within the meaning of Article 311 of the Constitution and was therefore void. It was contended that he could not be terminated from service without holding departmental inquiry as provided under the rules. Dealing with the above contention, the High Court held that if the very appointment to the civil post is vitiated by fraud, forgery, or crime, so the Supreme Court holds fraud, deceit. High Court here, DB holds, which is upheld by the Supreme Court, if it is fraud, forgery, or crime, or illegality, it would necessarily follow that no constitutional rights under Article 311 of the Constitution can possibly flow. Then, Lordship, 3 more paragraphs. May I continue, Lordship?
So anyway, what is the conclusion here?
I'm reading, Lordship. These are the concluding paragraphs. Basically, it was upheld, the dismissal after 27 years. Para 19 is very important, Lordship. I'll read that. You may mark, Lordship, para 16, 17. We are referring to different judgments, but para 19 is very important, that a flux of time will not make a difference. So that argument to say that I have been around, others were there, that also won't work. A flux of time with 27 years is also rejected. Para 19, Lordship, I'm reading. So, Placitum G, Lordship, I'll read the finding. The appellant obtained the appointment. Has Lordship got that?
Yes.
The appellant obtained the appointment against a post meant for a reserved candidate by producing a false caste certificate and by playing a fraud. His appointment to the post was void and non-est in the eye of law. The right to salary or pension after retirement flows from a valid and legal appointment. The consequential right of pension and monetary benefits can be given only if the appointment was valid and legal. Such benefits cannot be given in a case where the appointment was found to have been obtained fraudulently and rested on a false caste certificate. A person who entered the service by producing a false caste certificate and obtained appointment for the post meant for an SC, thus depriving a genuine scheduled caste candidate, which is the Article 14 argument, gets negated. Someone else's right you negated with this fraudulent act. Genuine SC candidate of appointment to that post does not deserve any sympathy or indulgence of this court. A person who seeks equity must come with clean hands. He who comes to the court with false claims cannot plead equity, nor would the court be justified to exercise equity jurisdiction in his favor. A person who seeks equity must act in a fair and equitable manner. Equity jurisdiction cannot be exercised in the case of a person who got the appointment on the basis of a false caste certificate by playing a fraud. No sympathy and equitable consideration can come to his rescue. We are of the view that equity or compassion cannot be allowed to bend the arms of law in a case where an individual acquired a status by practicing fraud. And the other words used are illegality, deceit, all of it. That's the judgment, Lordship.
All right. So anything else you want to add?
Lordship, I think he would rejoin. We broadly made our cases. Mr. Chaudhary would rejoin. One other option is Lordship had commanded that I should be here for 2 days. So if Lordship does want to take it tomorrow, I am available in the morning.
I'll get my instruction.
Yes.
in 10 minutes.
Sorry to what I just states, my lord. In the morning, two matters are disposed of. In the second matter, it's regarding the lady transfer.
Hmm.
I submitted the instruction which I received. In the instruction, the lady was transferred out from Bongaigaon to Dibrugarh. Subsequently, she was accommodated in the modified imping order. She was accommodated within the Bongaigaon, but it is 20 kilometers away, not in the BRPL. It is in the BGTPP.
Hmm.
So most probably, I wrongly said it within the, since she is within the accommodated, she is within the Bongaigaon, that is about 20 kilometers away. That may.
All right, all right.
Highly.
Yes.
So Lordship, from the judgment perspective, I'm done.
So not a very long matter.
Actually, Lordship, it can be very long if we are going to go through all the judgments again.
No.
I've carried those compilations in case my learned senior was to.
The learned single judges, we are not going to, there cannot be duplication of same
Yes,
work.
Lordship. Yes, Lordship.
Mr. Patwari. Then the matter gets postponed. Can't help it. You will not ask the judge to wait for.
Tomorrow morning, if Lordship would be indulgent.
Tomorrow morning question is a miscellaneous day tomorrow.
Post lunch, Lordship, if Lordship would be pleased to hold it.
You can try, subject to other matters being over.
I know, Lordship. Because I think from my side, I'm broadly done.
That's right.
Lordship would like to see the records because Lordship has been asking for them, though they were considered in all other cases, but we did keep the records handy with us in case Lordship issue.
No, it's on a law point. There
Yes,
is
Lordship.
no.
Actually, I'm obliged for that because Lordship, as far as my argument is also on the critical factor that which I've already outlined and I won't repeat. But if your entry is tainted, you can't be claiming for the benefits of the rules of the service thereafter. And in various circumstances, this has been considered in series of judgments. So we've got the judgments that are duly considered by the coordinate bench.
So Mr. Patwari, you make your reply and then we'll close the matter.
Lordship.
I can assist you, Lordship.
Yes, yes. You make your response and then we'll close the matter.
Yeah.
First thing is that, there is a direction of the.
No, first you tell Mr. Patwari, you first address the court. These issues which Mr. Chaudhary had argued the other day, all these arguments were made before the learned single judge.
Yes, yes.
And after considering those, the learned single judge has passed a judgment.
True,
Now it may be sustained, it may be set aside, but that is a matter of division bench.
True,
Why should the coordinate bench get into a elaborate exercise of again looking into the entire gamut of legal principle? It is a covered case.
No, in my humble submission, this is not a covered case, my lord,
Hmm.
because there it was emanating from Dibrugarh PS case number 926, and there were the allegations that the answer sheets were rewritten, and my lord, here that allegation is not there.
No. Allegation is
No,
through corrupt means by paying bribe, he has entered
Yes.
the service.
Yes, but
That is the point, not answer sheet written or not written. These are not,
yes, by corrupt
these
means.
are particulars.
Lordship will kindly appreciate how the criminal case was, my lord, set into motion. One particular unsuccessful candidate who says that he himself gave bribe but could not make it, he says that he filed 2 RTIs, my lord, before the APSC. In respect of one RTI, he says that the petitioner got 78, and in respect of the other RTI by the same APSC, he replies that petitioner got 80 months. So there is a difference of 2 months. But the select list will, Lordship, it will show that the petitioner appointed in the lesser mark, 78. So where is the question of getting entry into service by fraudulent means, my lord? They are just trying to put the cart before the horse. They are not establishing the facts in this present case, then bringing in the law, my lord. They're just trying to confuse your lordship with the facts of the other case, my lord. Where is the fraudulent means, my lord? Just because they make a statement they've taken a bribe, is it proved, my lord, before any competent court of law? It's not, my lord. So in my humble submission, the facts of the present case are not squarely covered by the decision rendered in the earlier APSC case, my lord. So, my lord, they will have to first establish that the manner in which I have been discharged midway during a departmental inquiry, my lord, it entails the confidence of this honorable. That's why, my lord, I wanted to refer to a earlier order of this honorable court. Lordship will kindly take up order dated 22/9/2022.
In this.
Yes,
case,
in this case, my lord. Where is the
22.
taint in this case, my lord? Just because it was held in the other case, the petitioner there not tainted. It doesn't mean that everybody's appointment is tainted, my lord. Order dated 22/9/2022, my lord. Lordship will kindly come to para 5. It has been brought to our notice that there is also a so-called notice dated so issued to the petitioner under Rule 9 of Assam Services Disciplinary Appeal Rules, read with Article 311 of the Constitution of India, on the charge that the petitioner is arrested in connection with Bhanagar PS case number so and a FIR lodged by Vedanta Vikas Das of Sonitpur, and he is in custody beyond 48 hours. The petitioner raises the contention that without completing or bringing the proceeding as per the so-called notice dated so to its logical end, the impugned order of discharge under Rule 21 of the Rules 1980 had been issued, and in doing so, the provisions of Article 311 had not been followed. Please so, learned Senior Additional Advocate General Assam refers to the provision of Rule 21 of the Rules of 1980, and by referring to the said rule submits that it is permissible for the authorities to discharge a temporary or officiating employee if either of the two conditions provided in subclause 1 or 2 are satisfied. According to Sri so, in the instant case, subclause 2 would be attracted and accordingly seeks to justify the order dated 31/12/2021, that is the impugned discharge order, my lord. In order to appreciate the rival stance, we are of the view that the records which may contain materials that the respondent had in order to arrive at their satisfaction that the requirement of Rule 21(2) of the rules was present would be required. So, my lord, in my humble submission, if from the records it is revealed that, my lord, the foundation of the impugned discharge order is relatable to some misconduct, then it will be stigmatic and punitive.
So what will you, supposing this opportunity is given to you, what is your answer? You will say you have not paid bribe.
Yes, my lord.
That's all.
Yes.
That's all, nothing else.
No, my lord, lordship will have to lift the veil and see whether though it is an inequally worded order, lordship will kindly say whether the foundation leads to some misconduct or not. If there is a live nexus, yes, then it is a punitive discharge.
But that argument has not been accepted by the learned judge.
No, in respect of those, there, my lord, all the answer scripts were perused by this honorable court. Everything was gone into detail. My lord, facts of those cases does not, my lord, in my humble submission, clearly covers here, my lord. Here, my lord, this is a separate.
So his answer scripts are available?
Lordship, the answer scripts were not produced here. The files were seen. Because the answer scripts were with the police and that was part of the investigation. The records meant.
What are the records?
His official records, his file only, lordship, which is there, which because it had come up in that time, a query had flowed, we said we'll make available. And on this also, lordship, is why, without prejudice to the argument that the entry is tainted, his own response to the SCN, which I have argued, lordship, is keep it in abeyance till the police happens. So, lordship, the supplementary charge sheet has been filed. He's facing the trial. And judgments of this court, of the Honorable Supreme Court, especially O. Chakradhar and Krishna Yadav, duly considered, the only basis for those discharges also was CBI reports or police reports. So this argument cannot be taken that till you are convicted, you should be kept in service and the seat held up for you.
That is not even my argument, my lord. What I'm trying to argue before your lordship is that, first, my lord, the judgment relied by my learned senior regarding that OBC caste certificate. As your lordship knows, the Supreme Court has laid down the detailed guidelines in Kumari Madhuri Patil. It is in a code in itself. And as per the directions of the Honorable Supreme Court, a scrutiny committee has to go into all the claims and objections regarding a caste certificate. So it is empowered by the Honorable Supreme Court itself, the committee. Where is such finding regarding to bring in that proposition to say that my entry was tainted? Well, it is too far-fetched in my humble submission, my lord.
All right. Anything else?
So Lordship, I'll also like to place some judgments in my favor. In addition to the Palak Modi case, which my learned senior, my lord, tried, Lordship, I will like to place, my lord, 1979 1 SCC, page 477, the manager government branch place another versus DB Velopia. '79 1 SCC can do by the.
Take a printer.
Lordship, Lordship, I'll rely on para 18, 19, and 25. If your Lordship permit me, I can directly come to para 25 where the proposition of law has been laid down, my lord. Para 25 at page 486. On similar set of facts, my lord, where a probationary or a temporary employee was sought to be discharged. Para 25. May I read it, my lord? Another facet of Mr. Virappa's contention is that the respondent had voluntarily entered into a contract of service on the terms of employment offered to him. One of the terms of the contract embodied in the letter of his appointment is that his service was purely temporary and was liable to be terminated at the will and pleasure of the appointing authority, without reasons and without notice. Having willingly accepted the employment on terms offered to him, the respondent cannot complain against the impugn action taken in accordance with those mutually agreed terms. The argument is wholly misconceived. It is borrowed from the archaic common law concept that employment was a matter between the master and the servant only. In the first place, this rule in its original absolute form is not applicable to government servants. Secondly, even with regard to private employment, much of it has passed into fossils of time. This rule held the field at the time when the master and servant were taken more literally than they are now, and when, as in early Roman law, the rights of the servant, like the rights of any other member of the household, were not his own, but those of his paterfamilias. The overtones of this ancient doctrine are discernible in the Anglo-American jurisprudence of the 18th century and the first half of the 20th century, which rationalized the employer's absolute right to discharge the employee. Such a philosophy, as pointed out by K.K. Matthew J., why this so-and-so, of the employer's dominion over the employee may have been in tune with the rustic simplicity of bygone days. But what philosophy is incompatible with these days of large impersonal corporate employers to bring it in tune with the vastly changed and changing socio-economic conditions and the most of the day. Much of this old, antiquated, and unjust doctrine has been eroded by judicial decisions and legislations, particularly in its application to persons in public employment to whom the constitutional protection of Article 14, 15, 16, and 311 is available. The argument is therefore overruled. My lord, may I just hand over to my senior man?
May it please your lordship. My lord, I have noted the arguments which has been advanced by my learned friend, my lord. Before that, since my colleague has placed this value past judgment, my lord. Now, before that, if your lordship would kindly come to the constitution once, my lord. Just in the context of this decision only.
Yes.
In fact, it's a new facet which I learned the other day. Now, Article 16(1), lordship will find these expressions in matters of employment, in matters relating to employment.
Really slowly.
Yes.
Article 16(1).
Yes, ma'am. (16)(1), my lord. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office. Now, my lord, this expression in matters relating to employment has been interpreted by the Supreme Court in my lord, the Beliapas case. It says, my lord, it not only includes at the initial entry. It is something like, my lord, there was at one point of time, there was a debate while exercising 226 power in contractual matters. Court should examine at the threshold, that is at the entering into of the contract, or 226 court jurisdiction can also be exercised at a stage after entering into of the contract. So, my lord, para, I think, my lord, 19 at the Beliapas judgment, my lord, it is now well settled at para 19 at 483, my lord.
Yes.
It is now well settled that the expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to the employment, which are incidental to employment and form part of the terms and conditions of such employment, such as provision as to salary, increment, leave, gratuity, pension, age of superannuation, promotion, and even termination of employment. So, my lord, in my humble submission, what follows from this is that even in matters of employment, my lord, which includes termination, I am entitled to equality. If, my lord, equality means, my lord, if I am not even denied the equal protection of law, end of the matter. Now, my lord, what is the case sought to be projected by the state? Now, my lord, state is trying to say that this is a case which is covered by, my lord, the earlier batch of judgment. It is clearly not covered by earlier batch of judgment because, my lord, facts are distinguishable. Now, in the earlier batch of case, my lord, there is a clear affidavit filed by the state where a stand was taken because of the, my lord, the report received from the Dibrugarh police, this action was taken. But in this case, we do not know why Rule 21(2) has been invoked. We are presuming. That is why we are making an argument of live connection, my lord, between the charge and the.
But there is a supplementary charge sheet.
My lord.
There is a supplementary charge sheet.
No, my lord. What I'm saying is, in the earlier case, in the writ petition, an affidavit was filed by the state, where a clear stand was taken. The decision to terminate was taken because a report was received from, the Dibrugarh police was investigating that case. There is no such stand taken in the present case. Well, not in criminal case, whether there is a charge sheet or not, that's a different thing. Where have they stayed? So therefore, lordship will have to look at the records before arriving at the conclusion that here is a case which requires invocation of Rule 22. The satisfaction was derived from what? We don't know. They have not disclosed. So lordship will have to lay your lordship's hand to the records. Secondly, my lord, I'm not making this argument to, I understand, my lord, assuming if otherwise, my lord, the facts are same, then as a coordinate bench, that judgment is binding on your lordship. But in all situations, a judgment may not be binding. That is what I will try to argue, my lord. Why it is not, that I will show, my lord, before I deal with the other points. Because
just one thing, Mr. Chaudhary,
yes.
I was just wondering, in the earlier batch,
yes,
the termination orders were issued in respect of those candidates also against whom there was no allegation, in the sense that the grains could not be separated from the chaff.
No, my lord. Termination orders were issued against those there were allegations on.
And
all were not terminated.
Others, they were.
Yes.
It's not against the entire batch.
Entirely.
It is against, there were 52 petitioners and 49 petitions. And these were the beneficiaries. Identified beneficiaries alone were terminated.
Okay.
Identified.
And the identification is on the basis of police report.
Well, broadly, lordship, the FIR follows the investigation. Investigation leads to the arrest. Arrest leads to then filing of charge sheets, etc. Different modus operandi by different people. And Mr. Chaudhary is correct to that fact. There are some who have changed their answer sheets. There are others who have paid bribes or claim to have paid bribes. So the FIRs, there are two, Dibrugarh, Bhangakad. And those who are identified in the totality of the investigations, in these two FIRs, action has been taken on them.
So by and large, it is the police report which
Absolutely.
is the basis of the action.
Absolutely.
Yes. Now, my lord, before going to other aspects, if your lordship would kindly have the earlier judgment for a moment, my lord. This is at page number 2023 GLT 800.
Yes, you can refer to the paragraph.
Yes. Okay, okay. My lord will kindly come to paragraph number 45.
Yes.
The office files as indicated above chronologically records the events taking place following the information received from Dibrugarh police as regards arrest of the petitioners in connection with Dibrugarh PS case, from the decision calling for detailed reports from the Dibrugarh police for taking further action, to receiving such report in connection with arrest of the petitioners, to the decision to withdraw services of the petitioners, pending actions to be taken by Personnel Department, Government of Assam, to obtain the views of the Judicial Department before taking the final decision, and to obtaining the approval accorded by the Chief Minister of Assam, together with the views of the Advocate General before the petitioners were discharged from service by orders of the governor, and the same fines recorded in the respective office file. So this is the factual background of that case. This is not unlike in the present case. Clearly, the allegations of irregularities on the part of the petitioners are not allegations of any irregularities, negligence, and inefficiency and misconduct taking place during discharge of their duties, post-recruitment, or after having been appointed to public office. The allegations against the petitioners in indulging in gross irregularities and fraud involving payment of illegal gratification for securing appointment to public offices are apparently of a pre-recruitment period, that is before they were appointed to the public office. In the understanding of this court, the element of misconduct which reverberates in the submission made on behalf of the petitioners is attributable only in respect of a period and subsequent to the valid initial appointment. Now, this is important. Not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during recruitment process or before appointment have been made or before a person is born into cadre or service would constitute misconduct. A vain attempt was made when reliance was placed in para 37 of the Palak Modi to say that use of unfair means in the evaluation test, confirmation test would certainly constitute misconduct. I think, my lord, JLR authorities will have to be careful, my lord. The GLT authorities, I mean, this print, they have not checked the proof, my lord. All the words are joined. A reliance of place vis-a-vis the facts and circumstances in the present case is altogether out of context. In Palak Modi, the private respondent herein were already been appointed as provisionary officer way back in 2006. In due course, State Bank of India informed that they were due for confirmation service and therefore they are to appear in the test proposed to be conducted in 27/2/2011. The private respondents appeared in the test held on 27/2/11, but their names did not figure in the list declared on 10/5/11, primarily on the ground that Institute of Banking Personnel Selection, which body was entrusted with the task of preparing the examination papers and evaluating the answer sheets, submitted report to the bank that some of the candidates, including the private respondents, were suspected to have used unfair means. Thus, paragraph 37 of Palak Modi, which makes mention that use of unfair means during evaluation test, confirmation test would constitute misconduct, was only in respect of the text conducted for the confirmation of service. No law was laid down in Palak Modi that misconduct can also be stretched back to a period prior entering into service and for illegalities and irregularities committed during the selection process.
as the misconduct cannot be pre-recruitment phenomena, the very bedrock of the submission made on behalf of the petitioners, that impugn action being founded on misconduct, therefore principles of natural justice and or provisions of Article 311 could not have been dispensed with in the considered opinion of the court, does not hold any water. My lord, with utmost respect, with all humility at my command, my lord, the learned single judge has committed to error. Of course, that's an argument which I'll advance in the writ appellate court. I have already done it once. That's why the appeal has been admitted, my lord. Now the issue is, the learned single judge, while taking the particular view in this matter, has taken the view that we could not cite a single judgment where, my lord, prior to entering into service, if somebody indulges in some unfair means or does some indulges themselves in some omission or commission, whether that can be construed as a misconduct for the purpose of either principles of natural justice or Article 311. My lord, this proposition was answered by Supreme Court in Palak Modi itself. My lord, why the learned single judge confined to para 37 only, I don't know. But when we cite a judgment, my lord, the judgment has to be taken note of as a whole. So therefore, now my lord will kindly come to Palak Modi's case for a moment. Why the view is not correct? My lord, citation is 2013 3SCC 607. My lord, in the Palak Modi's case, the provisionary officers were on probation. It was towards confirmation of the service, they were required to pass a test. It was in that test, they were indulged in, my lord, some unfair means. Now, what is the facts in the ACS officer's case? They resorted to some wrongdoing while entering into the service as a probationer. What difference does it make, my lord? Whether it is towards initial selection or it is towards confirmation. It is towards recruitment. Now, please come to para 37.
Yes.
Let us come to read 36 also, my lord, to appreciate as to what we are trying to canvass, my lord. There is a marked distinction between the concept of satisfactory completion of probation and successful passing of training tests held during or at the end of the period of probation, which were sine qua non for confirmation of a probationer, and bank's right to punish a probationer for any defined misconduct, misbehavior, or misdemeanor. In a given case, competent authority may, while deciding the issue of suitability of a probationer to be confirmed, ignore the acts of misconduct and terminate his service without casting any aspersion on stigma, which may adversely affect his future prospect. But if misconduct, misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employer for an act of misconduct. The use of unfair means in evaluation test, confirmation test held by bank certainly constitute a misconduct. My lord, this is an authoritative pronouncement. It is not a mere obiter dicta in the facts of a case. It says, my lord, use of unfair means in evaluation test, confirmation test held by the bank certainly constitutes.
Mr. Chaudhary, before you came, this question I was asking to Mr. Patwari. I understand the thrust of your argument.
Yes.
Let us move away from everything for a moment. Let us test the argument from this side. Of course, the view to be taken by the court is a different matter. Your client has not paid any money or any bribe, right? If a notice is issued, he will come and say that he has not done it. But from the employer's point of view, he was in probation.
Yes.
The employer thinks that whether he has done it or not, now he
I'll not look into it.
I'll not look into
But
it.
at the same time, I'll not detain him.
Yes.
That they have not done, that they could have done.
Why?
That is my case.
Why they have not done this?
They have not done it. They have invoked, my lord, the 21(2) can be invoked when? That's the whole difficulty, my lord. That means now, my lord, there's a simple, distinction, my lord. For the purpose of whether I'm provisional, now, my lord, provision period is going on, there are certain allegations. Even during the period of provision also, the employer can find out whether I should be retained or not, having regard to the allegations. Now, employer may still say, sorry, I do not like to go into all these allegations. At the same time, I don't want to retain any tainted person. That is a permissible course of action. That has not been done.
Why do you say so?
I say so because they've invoked 21(2). Kindly see, what is 21(2), my lord? Page 22.
Subclause 2.
Yes.
See, merely because this provision has been mentioned in the order, apart from mentioning this provision in the order, that there you may have a point.
Yes.
There are legal experts of different grades, different standard.
No, my lord.
But if this 21(2) was not mentioned, you
Yes.
agree that there was nothing that your clients could have had to complain
No,
in
my
this.
lord, as a while exercising statutory power, they may have to refer to a provision. Otherwise, my lord.
Mr. Chaudhary, please appreciate the question. I am saying, here is a situation, your client was appointed in the agriculture department. He was on probation.
There is some cloud.
While he was in probation, some things were happening.
Some cloud was there
Something to
regarding.
do with him, but something to do with the entire series. The man in the Elmo affairs being involved in these proceedings, employer feels, no, will not keep him. Whether the allegation is right, the FIR leads to conviction or not, we're not going into it. Discharged. What is wrong with that order?
No, my lord, there is a wrong for the simple reason. Now, my lord will kindly see, as a provisioner, I have a right to be confirmed. Now, if that right is to be curtailed, now the authority wants to curtail that right, come in the way, or if they would like to discharge me or terminate me. Now, my lord, they need to have a very good reason for that.
Where is that law? I want to know that.
Yes.
Where is it necessary to give reason to discharge a provisioner?
No, I think my lord, Palak Modi is para 36.
Where is it?
That's the answer. Please see para 36, my lord. Come to Placidum C, para 36. This is the best, example perhaps. In a given case, Placidum, my lord, para 36 of 2013 3 SCC 607.
Yes, para 36.
Page 633. Placidum C.
Yes.
In a given case, the competent authority may, while deciding the issue of suitability of probationer to be confirmed, ignore acts of misconduct and terminate his service without casting any aspersion on stigma, which may adversely affect his future prospect. That is the question lordship posed. If the misconduct, misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employer for an act of misconduct.
So what does it mean?
It means, my lord, while trying to, confirm me when an exercise is undertaken, and in that exercise, you take note of certain misconduct of mine towards not extending my service or towards discharge, then this will be attracted. This is what has happened.
So therefore, if I have understood your submission correctly,
yes,
in this matter, a notice should have been issued.
Yes.
You would have come and said, I have not paid bribe.
Yes.
Then that's the end of the matter. They would be bound to pay.
Question is, I would have got an opportunity to defend myself. Now, my lord, there is a police report. Now, we all know, my lord, we are presumed to be innocent unless we are convicted. So, till that point of time, my lord, I am innocent.
Now, on what basis you have taken away my job? Am I not entitled to know? Everything can't be so, my lord, in darkness. Yes, when you undertake an exercise for, whether somebody should be confirmed or not, in that exercise, or to find out suitability, in that exercise, you don't take note of the, allegation. At the same time, you don't retain him. That's a different case. But here, my lord, the Honorable Supreme Court says then it's the duty of the court to leave the way and find out. In fact, what has fallen from your lordships is that Gujarat Steel Tubes case, that's a judgment by Honorable Justice Krishnaya, 1982 SCC Nigi. That the Gujarat Steel Tubes case, where, my lord, this view has been taken. But that would be in a different circumstance, not for the purpose of imposing punishment, for the purpose of finding my suitability when you undertake that exercise. Then you don't take note of, yet you don't want to retain me. That is permissible. That they have not done. There is a distinction, my lord. Here, the exercise is to punish me. There, the exercise will be to find out my suitability to retain. Or to
No, punish you means by whom?
Yes, this is not an exercise where they have undertaken to find out my suitability for the job. Because of the police report or whatever action, my lord, they're punishing me based on some allegation. And I don't even know what is the allegation. It is entirely the subjective satisfaction. I don't think, my lord, there is any gray area on this branch of law. This is very clear, my lord. In such a situation, my lord, in my humble understanding, the court will have to leave the way. Or else, my lord, it will be, maybe, my lord, in a given case, okay, but this might empower the executive to do many mischief, my lord. End of the day, lordship will balance the legal principles. So therefore, my humble submission is, my lord, it's clearly a case where they have taken note of some misconduct. What is the misconduct? Alleged, my lord, unfair means adopted by me.
So that's what I'm asking. What is the basis to show that they have taken note of misconduct?
Then they will have to show why they have dismissed us.
They have taken note of allegation, not misconduct.
How can there be allegations, my lord? No, that allegation itself is misconduct.
Mr.
No, my lord.
Chaudhary, this is a very interesting and tricky area. Therefore, I would be impelled to put this to you.
Yes. Before that, can I place one?
Misconduct,
Before that,
yes.
can I place one judgment that will clarify everything, my lord?
Yes.
Very good, yeah. No, that is some good. Khatri. Judgment edition. My lord will kindly have 1981 2 SCC 493.
1981.
1981 2 SCC 493. Now, what is the credibility of this police report in a proceeding under 226? Now, this is a famous case, that Bhagalpur blinding case, my lord, where 21 police officers were, my lord, blinded in police custody. So, my lord, that police report was sought to be used. Now, what is the view Honorable Supreme Court has taken? Please come to, my lord, page 497. Section 162 of the Evidence Act is quoted towards the bottom, my lord. Then, my lord, will kindly come to next page 498.
Yes.
Why police report cannot be the basis? It bars the use of any statement made before a police officer in course of an investigation under Chapter 12, whether recorded in a police diary or otherwise. But by express terms of this section, this bar is applicable only where such statement is sought to be used at the very inquiry or trial in respect of an offense under investigation at the time when such statement was made. If the statement made before a police officer in course of an
Yes.
If the statement made before a police officer in the course of an investigation under Chapter 12 is sought to be used in a proceeding other than an inquiry or trial, or even at an inquiry or trial, but in respect of an offense other than which was under investigation at the time when such statement was made,
the bar of section 162 would not be attracted. This section has been enacted for the benefit of the accused, as pointed out by this court in so and so. It is indeed to protect the accused against the user of statement of witness made before a police during investigation at the trial, presumably on the assumption that the said statements were not made under circumstances inspiring confidence. This court in so and so versus so and so approved the following observation of so and so. As it seems to us, it is to protect the accused from being prejudiced by statement made to police officer who, by reason of the fact that an investigation is known to be on the foot at the time the statement is made, may be in a position to influence the maker of it, and on the other hand, to protect the accused persons from the prejudice at the hands of person who, in the knowledge that an investigation has already started and are prepared to tell untruths, and express his agreement with the view taken by division bench of the Nagpur High Court in so and so, that object of this section is to protect the accused both against overzealous police officers and untruthful witnesses. Protection against the use of a statement made before a police during investigation is therefore granted to the accused by providing that such statements shall not be allowed to be used except for the limited purpose set out in the proviso to this section at any inquiry or trial in respect of the offense, but which was under investigation in the time when such statement was made. Now, this is important. But this protection is unnecessary in any proceedings other than an inquiry or trial in respect of an offense under investigation, and hence the bar created by this section is limited bar. It has no application, for example, in a civil proceeding or in a proceeding under Article 32 or 226 of the Constitution, and a statement made before a police officer in course of investigation can be used as evidence in such a proceeding, provided it is otherwise relevant under the Indian Evidence Act. Now, it is not relevant under the Indian Evidence Act, my lord, any statement made before the police officer. Now, there are a number of decisions of various high courts which has taken this view, and amongst them, they may be mentioned the decision of Jagmohan Reddy in so and so. The present proceeding before us is a writ petition under Article 32 of the Constitution, filed by the petitioners for enforcing their fundamental right under Article 21, and it is neither an inquiry nor a trial in respect of an offense, and hence it is difficult to see how sections 162 can be invoked by the state in the present case. The procedure to be followed in the writ petition under Article 32 of the Constitution is prescribed in Order 35 of the Supreme Court rules, and Sub-Rule 9N of Rule 10 lays down that at the hearing of the Rule 9C, if the court is of the opinion that an opportunity be given to the parties to establish their respective cases by leading further evidence, the court may take such evidence or cause such evidence to be taken in such manner as it may deem fit and proper. And obviously, the reception of such evidence will be governed by provisions of the Indian Evidence Act. It is obvious, therefore, that even a statement made before a police officer during investigation can be produced and used in evidence in a writ proceeding under 32, provided it is relevant under the Indian Evidence Act, and Section 162 cannot be urged as a bar against such production. So if a statement made before a police officer is otherwise admissible under Evidence Act, then only that can be taken note of in a proceeding under Article 32 or 226. Now, my lord, what is the credibility of this so-called, premise?
No, I've understood your argument, Mr. Chaudhary. That's what I wanted to ask you.
Yes, yes.
Do you agree that in case of a probationer, if he is discharged by a non-stigmatic order, which is not founded on any allegation of misconduct, then it does not partakes the character of an order of dismissal or removal within the meaning of Article 300.
It is then the motive, not foundation.
Correct. So then it does not partake the character of an order of dismissal or removal under Article 311.
Yes, yes.
In those circumstances, all these judgments pertaining to 311
will not apply.
Would not apply.
Yes.
Correct. So the first question here would be, in this case, is this order stigmatic, and has it been founded on an allegation of misconduct?
Yes.
This is the first question.
Yes.
If the answer is negative, in the negative, then even the learned single judge's judgment will not be attracted here.
Yes.
There is no question of 311. There is no allegation of misconduct.
Yes.
So where is the issue? Where is the scope of ascertaining whether the misconduct is prior to-
Because of their affidavit, they're relying to
No,
the
no,
police.
they may file anything in affidavit, you may argue your, but the court will go by what?
No, my lord. Lordship will kindly, no, I have followed, my lord. What has fallen from your lordship is absolutely correct. That is only one facet.
Let me.
No, what has fallen from your lordship is one facet. The immediate second facet is, even if an order is non-stigmatic, it necessarily, my lord, it does not therefore follow that it was done in bona fide exercise of
No,
power.
no, no, no. What I wanted to say is something different. And the reason why I'm saying is, it will be nice to elicit some response from both of you, because you have already made elaborate arguments.
Right.
There is a judgment of the learned single judge. And this decision has to be on the teeth of that judgment. We will see when the time comes. But what I am saying is, this judgment is almost entirely on the issue of what would be a misconduct, whether some foul play before entering the service.
That would be a misconduct.
But I am on a slightly different tangent.
Yes.
I am saying, if there is no allegation of misconduct at all,
Written in the order.
or anywhere, written in the order or otherwise also, if due to supervening developments, the employer thinks that we don't want to keep this employee anymore. Let him go. Can this recourse not be taken when the employee is in probation? That's the question I'm asking.
Then authority in the records, they must express that view. That here is a case, there are allegations, we would not like to go against all this, yet we do not like to retain them.
So let us see the
Yes.
record. Yes.
Just 2 sentences before I show that. Number 1, Lordship. Broadly, it comes down to 3. They rely on Khatri. 1981, that's the Khatri case, if I recall. Thank you. So they rely on Khatri. We rely on Krishan Yadav and Chakradhar. That's where a police report can be the basis. Khatri says no. Khatri is considered the 1981 judgment in para 9 of the coordinate bench. Specifically, and finally, this argument that they rely on Khatri, we rely on Krishan Yadav and O Chakradhar is para 48. The second limb of the argument is Palak Modi. Palak Modi is a case of 2006 appointment, where it's valid, no allegation on the appointment.
No, confirmation.
I'm coming to 2006 is the appointment.
Yes, probation.
2009 is the confirmation test. 2011 is when the allegations come. Now, Lordship, there is no allegation in Palak Modi about any kind of illegality, deceit, fraud, any kind of tainted entry at the point of entry. It is at the point of confirmation.
Confirmation.
That's the second point, which is para 46, which we've already gone through. Second. Third, and then I'll show the record. Let's compare the 2 facts for a moment. 52 petitioners and the petitioner herein, all are from the same APSC batch examination. All are part of 2 FIRs, Dibrugarh, Bhangagarh, Crux. All have the same, after a detailed exercise, which para 48 on 6 onwards, the learned single judge, after going through everything, says it's a thorough investigation, holds that these are the identified persons, not the rest of the batch. So you cast a wider net, you narrow it down, which includes the petitioner herein. He is also not just the batch, allegation, FIR, arrested, as are the others. In his case, I've already pointed, he comes through the route of a show cause notice, but dehose that. Dehose his reply that he says keep it pending till the end. The fact is that everything in the file is similar up to this, except a point to the show cause notice, which according to me has no value in any case if the entry itself is tainted. That's why the determinative factor is the point of entry. And the misconduct argument can only be post a valid argument. I'll show the file. Lordship, in this, the 2 things which are flagged also. One is on the note sheet, at the end of it is the secretary's, sorry, I'm so sorry. So, Lordship, you will note that below the note sheets are all the arrest and the newspaper clippings. then the secretary's report is flagged. The secretary's noting is flagged. So below that is all the arrest, everything, which is right at the beginning when the note sheet starts, which is in 2019, Lordship. So 2019 is arrest and all, then comes the secretary's note.
চক্ৰধৰ আৰু যে কৃষ্ণ যাদৱ মই যে ডিষ্টিংগুইছ কৰিছিলো সেইটো কোৰ্টে ডিল কৰা নাই নহয় চক্ৰধৰ আৰু হেৰি মোৰ আৰ্গুমেন্টৰ কনটেক্সটত ডিল কৰিছে নাই
So some opinion has been recorded.
Yes, Lordship.
My lord, can I just come in, my lord?
That opinion is based on the judgment,
On what basis?
the basis of the judgment.
A judgment rendered in another case, how can you draw an opinion that this man has done X, Y, Z?
Lordship, the question and the query was, the query of that was, because I am personally involved in that, so I can say that, Lordship. The query came identically on the question that he is one of the arrested people in the APSC matter. He also went to jail. He's named in the FIR. And in his case, he approached this court in seeking that he was suspended. Then he sought reliance on Ajay Chaudhary, etc. What should we do? This is when we came in, when the agricultural department and the personnel department met for the first time. And our argument on that was clearly, how can the state is obligated to act for an identically
So
placed.
if he is guilty of fraud, what is he doing at home? He should be in the jail. You have
Lordship, that
already
is
declared that
Lordship,
he
that is not the
is
government's role.
committed. Huh?
That is not the government's role. Lordship.
Look at the file. What is the
Lordship,
opinion?
his name, he
Who
came
is
into.
the government to hold?
No,
him?
Lordship, what, Lordship, respectfully, on this one, the government, with regard to the charge sheet, etc., the police court is all going on. He is identically placed there. It is not for the personnel department to do so, Lordship. And he was arrested. The arrest is there.
The opinion in the file, secretary's conclusion, see the conclusion.
Yes, Lordship.
This is a finding recorded by the secretary.
But Lordship,
Have a
respectfully.
Look at the.
Yes, Lordship.
My lord, we also may be allowed to, so that we can make the argument, my lord.
Lordship, that is for the court.
No, first.
No, in that case, you must file an application seeking privilege. Otherwise, you can't.
Let's see the conclusion.
Yes.
drawn.
Yes, Lordship.
Yes. What is the conclusion?
The Lordship, it starts on para 4. There are three things.
No, just the subpara conclusion.
Yes, Lordship, there are three parts to that conclusion. There is not one. That's what I'm saying. The first one, Lordship, quotes provisor 23 of the rules, Lordship, which is completely quoted, Lordship. Then it says, Lordship, as per 21, discharge or revision it is stated a temporary, that is quoted. And then it says, in view of the above facts, the ADO may be discharged. Above that, Lordship, it's quoting some Supreme Court judgments, which is based on the, and it is in light of the opinion. Right, Lordship? But it ultimately goes to para 20, rule 21. And 21, there is an important word, Lordship. It basically says, can you just open 21? Rule 21.3. 2. Lordship, it clearly says, if he was not qualified for appointment or he had not. So if he was not initially qualified for appointment, the key to 21 is if you are initially not qualified, which is where he falls in the identical bucket. The only difference is this, what I call miraculous journey. And I'm not going into it deep. Miraculous journey of him in a particular department, staying under the radar as compared to everyone else. That is the only difference.
All right, so that's all.
Well, I'll just take 5-10 minutes time, my lord. My lord, my lord,
We'll have the records.
We'll leave it with the court.
my lord, to answer Khatri, my learned friend is referring to Krishan Yadav and Sakradhar's case. My lord, we will go through those two judgments, my lord. Lordship knows when CBI takes up investigation, there are two ways. Initially, CBI does a preliminary inquiry. Then when, my lord, based on the preliminary inquiry, they find something, then they go for a regular inquiry. The moment regular inquiry is, ordered, then it means a case FIR has been registered. Now, in both Kishan Yadav and my lord Chakradhar, there was a preliminary inquiry, and that is an administrative inquiry. That was taken note of. That is why that was permitted by the Supreme Court. This aspect, though I argued, I submitted written argument also, my lord, but that has not been dealt with. On the two cases relied upon by Mr. Singh, Mr. Chaudhary contends that both Kishan Yadav and Chakradhar were only based on a preliminary police report, which was an administrative nature. On section 6. So, my lord, this issue, my contention is recorded, but it was not never taken to the logical end. My lord, when there is my lord, what happened in those Punjab case? 3 judges committee was constituted by the, initially, my lord, the judgment of the Punjab and Haryana High Court was interfered by the Supreme Court. Then a committee of the judges were constituted. Meticulously, each and every, candidates, answer scripts were examined. Then, my lord, some of them were weeded out. So those are not based on police report. Those are administrative actions, which can form the basis. But here in the case, APSC case, as well as in this case, what is
So there was no administrative inquiry into the whole matter, nothing. Only
Nothing.
police cases.
Yes.
What happens if they're acquitted ultimately?
Yes, then
Which is what Krishan Yadav and Chakradhar is.
What happens?
Nothing, Lordship. Krishan Yadav and Chakradhar is very clear that it doesn't matter. If they are, because Lordship, in fairness, and that is the reality of law, unfortunately.
No.
It is the reality of law, Lordship. No, it is not. No. It is, which is where our practice also comes in, with due respect, is about how the conviction is very different to the process. And that's the reality of the trial process. And
Mr. Kohli, I'm just trying to
of
understand.
course,
a few
Lordship, I'm to assist and I'm an officer of the court first.
See, there are a few verticals to this matter.
Lordship.
If one wants to go into, one can go into,
Yeah, of course.
and perhaps one has to go into. But what I'm asking you is that the whole action it's triggered, first of all, by some allegation, FIRs, allegation of bribery. Then the persons who are believed to be involved in this process, including the candidates, have been identified by the police. But this identification by the police by itself does not have any evidentiary value.
Exactly.
Unless a charge sheet is submitted, charges are framed. And in the process of trial, supposing the criminal court says no, none of the allegations have been
Right, Lordship.
established against these persons. You are saying then also it doesn't matter.
No, Lordship. May I answer, Lordship? No. And I will come down for a minute because these arguments have happened. For me, it's deja vu. These very arguments have been professed before that judgment came. Now, let me take a reverse. So I'll give our argument, which was there. What are we talking about is public office. So let's ask ourselves a question. X is a tainted official on whom there's an allegation of taking a bribe, sitting as a police officer in the ACB. Public office is about public trust. The state, can it have or be forced to have the services of such a person? This argument was also professed. It may not feature.
Just sorry to interrupt you.
Of course, Lordship.
So next year, when people are appointed and put on probation, somebody lodges an FIR saying that they are involved in bribery, which is a cognizable offense. The police has to register a case.
Fair question, Lordship.
Will it not be enough to decide?
Not Lordship, because in this case, again, the second part was there were 4 steps. There was not just an FIR with an allegation. There was given the magnitude. So, Lordship, for a minute, the APSC scam rocked the state. PIL came in, CBI reference came in. There were demands of scrapping the whole examination. A committee was formed. Multiple things happened. APSC was not just another FIR with just another allegation. In that entire
So what
thing-
is the principle? That's what I'm asking.
I'm
What
coming
is
to
the
that,
principle?
Lordship. Yes, Lordship. In that particular case, the inquiry or the investigation was thorough, went up to a forensic level, went up to every level with everyone. That's how the shafting, the difference, as I call the grain and the shaft was segregated. It was not about all. And in all cases, that entire exercise and argued over several months has been commended, which is a finding of the Honorable Single Judge, which is the benefit, the identified beneficiaries. It comes to that and says the thoroughness of the investigation. That investigation includes Mr. Aloy.
So, Mr. Kohli, what I am asking you.
Of course,
see,
Lordship.
We put aside the outcome or result in this writ petition for now.
Lordship.
The queries are more on the principles.
Of course.
A thorough inquiry by police is good enough to hold someone guilty of some.
O Chakradhar, Krishna Yadav. I can read just because. Yes, Lordship, please. Let's see, Lordship. Let's go
Or
to
should
O
we continue
Chakradhar.
after lunch?
Yes, my lord, I'll place that Krishna as judgment, my lord. That will also throw enough light on it.
Because I'm trying to understand the
Yes.
principles.
No, my
Why
lord,
not?
there's a very thin line of distinction, my lord,
There appears to be.
Yes.
uh,
between
although-
as to what is a misconduct and what is suitability.
No, Mr. Chaudhary and Mr. Kohli, I must put it to you very clearly. What is going through the mind of the court? First of all, I believe and I understand the law is that the protection available to a probationer is very on a very thin-
Limited, very limited.
The employer can simply say that, sorry, we don't want it, go away. The protections and safeguards comes only when it is something more than just showing you the doors. Just showing you the door, and it can be arbitrary. Arbitrariness is not a ground. While discharging a probationer, arbitrariness is not a ground. But it should not be a mala fide exercise. It should not be an exercise which is tainted with some other. That is why motive, foundation, these principles come in. If the motive is that you are involved in a police case, so we don't want you, that's perfectly fine. But because you are involved in a police case, we are throwing you out, then it is the foundation.
Yeah.
That is when it comes in. But it has to be reflected in the order. There has to be a nexus. If the order does not say anything about it, then the matter is entirely different. So this is where the court is trying to figure out that why cannot be said that this is a case where motive was,
My lord,
police case was the motive and not the foundation.
The example which your lordship is trying to give would be applicable in those cases where there is shortcomings in somebody's performance. These and that, my lord, one is not up to the mark.
Where is the judgment that it will applicable only to these things?
I'm trying to, I'll at 2 o'clock, I'll come up with 1 or 2. judgments.
Lordship, that in one sentence only is whether one should read into the discharge order. Simplicity.
That firstly, as far as the probationer is concerned, his rights are very limited. It is only in certain situation when a probationer is entitled to the benefit of Article 311 or the principles of natural justice. Now, the question which your lordships, has raised is, what happens in a given situation when there is an allegation against a probationer? It comes to the notice of the employer, and employer decides, I'm not going to inquire into this allegation for the purpose of finding out whether it is true or wrong, or whether I should take any action on the basis of that. But as an employer, I have decided that I will not retain him. So
pass a simple termination simpliciter, then Supreme Court says in such a situation, it will be a termination simpliciter, it is not punitive. That is one line of thinking, my lord. It developed with that. Then, my lord, along with that view, several associated views also emerged. Now, even if injurious findings are not recorded, then also it could be punitive. So what is the test to find out whether actually it is punitive or it is a termination simpliciter? So these are the two views, my lord, which trouble us at times, my lord, because the distinction is so subtle and yet it exists. And it is, I think this honorable court has a duty to, my lord, recognize that distinction. Otherwise, my lord, everything will get blurred. Now, precisely on that line, the Gujarat Steel Tubes case is mine. This is, my lord, 1980, 2 SCC 593. I'll refer to 3 paragraphs, my lord, that perhaps will answer every aspect of the matter.
Yes.
My lord will kindly come to page 614, paragraph 46. The core question. Right at the forefront falls the issue. What had happened in this case, my lord? This Gujarat Steel Tube was a huge industry in those days in Gujarat. There was some industrial unrest. Then, my lord, there was an en masse, my lord, discharge of many, workers, my lord. It was which, my lord, led to this litigation. Right at the forefront falls the issue whether the order of discharge are, as contended by Mr. Tarkunde, de facto dismissal, punitive in impact, and therefore liable to be voided if the procedural imperatives for such disciplinary action are not complied with, even though wrapped in a silken phrases like termination simplicity. It is common case that none of the processes implicit in natural justice and mandated by the relevant standing orders have been complied with. Were we to construe the orders impugn as punishment by of discharge or dismissal? But Mr. Ashok Sen impressively insists that the orders here are simple termination with no punitive component, as on their face the orders read. To interpret otherwise is to deny to the employer the right not to dismiss, but to discharge when law gives them the option. So this was the core question, my lord. My lord will kindly come to paragraph 53 and 54. 53 at 617. Masters and servants cannot be permitted to play hide and seek with the law of dismissal, and the plain and proper criteria are not to be misdirected by terminological cover-ups or by appeal to psychic process, but must be grounded on substantive reason for the order, whether disclosed or undisclosed. The court will find out from the proceedings or documents connected with the formal order of termination what the true ground for the termination is. If thus scrutinized, the order has a punitive flavor in cause or consequence, it is dismissal. If it falls short of this stage, it cannot be called a punishment. To put it slightly differently, a termination effected because the master is satisfied of the misconduct and of the consequent desirability of terminating the service of the delinquent servant is a dismissal, even if it had right in law to terminate with an innocent order under the standing order or otherwise. Whether in such a case the grounds are recorded in a different proceeding from the formal order does not detract from its nature, nor the fact that after being satisfied of guilt, master abandons the inquiry and proceeds to terminate. Given an alleged misconduct and a live nexus between it and the termination of service, the conclusion is dismissal, even if full benefit as on simple termination are given and non-injurious terminology is used. My Lordship, in order to arrive at the conclusion that the mental process of the employer, that though there are allegations, but I will not look into it, but will not retain him. Even in that process, Lordship will have to undertake this exercise. The reasons may not be recorded in the formal order. It can be discernible from the, my lord, connected records. Now, here in this case, my lord, let us not go to all these case laws and all. Simple case is, they say that there is a police case which has some live connection regarding some wrongdoing by me when I entered into this service. Now, they are relying on a police report, though they have not spelled out in so many words. I think the records will reveal.
Yes.
Now, if they are relying on that, then my lord, then it is their decision is premised on some misconduct. The misconduct is relatable to my entry into the service. We do not know, that may be correct, that may not be correct. That may lead to conviction, that may not lead to conviction.
No, but that interpretation will take you straight in the domain of the judgment of learned single judge.
No. There, as I have already pointed out the distinguishing features, my lord. In my humble submission, my lord, that judgment, my lord, two aspects were not correctly decided. Therefore, I am not saying it is not binding on your lordships. But I'm just pointing out, my lord, because, my lord, even, my lord, when it comes to a precedential value, my lord, lordship will definitely look into what is the basis of the judgment, what are the facts. Now, as I have already indicated, the facts of those cases are different. There was a clear-cut stand in the affidavit that based on which is recorded in paragraph 52, which I read, that based on the report of the Dibrugarh police, it was done. Now, there, his lordships took note of that Ishan Yadav and Sakradhar without realizing that there were preliminary reports which are administrative in nature. Therefore, those could have formed the basis. Here, as well as in the APSC cases, absolutely no administrative order. Anyway, my lord, that is one aspect. So, coming to the facts of this case, what my humble submission is, the records would reveal what is the actual reason. And records, as the lordship has already indicated, there is a punitive flavor. If there is a punitive flavor, my lord, there is no escape from the conclusion that Article 311 will be attracted. Though, yes, as a proposition of law, if injurious records are, misconduct is not taken note of, in which case, my lord, 311 is not attracted. But given the facts of the case, given the, my lord, judicial, test which has been laid down in para 53, your lordship will have to take note of not only the non-injurious order recorded in the as revealed from the order, but also from the records. End of the day, my lord, their satisfaction, why they are invoking Rule 21, has to be seen tested. My lord, for example, my lord, under Income Tax Act and all this case, that expression reasons to believe, my lord, whenever there is a raid, supposing, my lord, an ITO, forms an opinion that Mr. X is in possession of undisclosed income, then he has reasons to believe. Now, my lord, that reasons to believe at that stage is, my lord, subjective. And that subjective satisfaction is always judicially reviewable, my lord. And the moment that subjective satisfaction is questioned in a court of law, then, my lord, it is the duty of the revenue to place before the lordship the materials which form the basis of the satisfaction. Now, from the records, the lordships will have to test what is the basis of that satisfaction that I am entitled to be discharged from service, which is that motivating factor which guided the authority to take this recourse. So, my lord, then, my lord, the entire cat will be out of the bag. So, therefore, my lord, yes, in a given case, it is possible to take that view that yes, there is allegation. I will not take note of it, yet I do not like to retain it. But in that process also, my lord, to come to a finality that it was not influenced by any other punitive flavor, my lord, lordship will have to undertake the exercise as mandated in para 53. This line is very important, my lord. The court will find out from other proceedings or documents connected with the formal order of termination what the true ground for the termination is. If thus scrutinized order has a punitive flavor in cause or consequence, it is dismissal. If it falls short of this stage, it cannot be called a punishment. To put it slightly differently, a termination effected because of the master is satisfied of misconduct and of the consequential desirability of terminating the service of the a delinquent servant, is a dismissal, even if had the right in law to terminate with an innocent order under the standing order or otherwise. So this qualifies the whole, my lord, a gamut of the issues in my humble submission. This is a paragraph. This is very important, my lord. Therefore, my humble submission is, my lord. Otherwise, I'll be repeating my argument. It's a simple case, my lord, where certain misconduct has been taken note of for the purpose of dismissal, which is not permissible, my lord. That's my humble submission.
Would you like to say something?
10 sentences. I was just writing down the 10 sentences that I thought I'll close.
Right.
Lordship, I'm not reading the judgments. They've been considered.
Also kind permission.
Yes, but one thing,
Yes.
I will request both of you to give a written argument.
Okay.
And I
Then
will
in
not-
that case, Lordship will give little time towards the
how
weekend, my
much,
lord.
how much time you say?
Monday morning, next Monday morning at 10.
Monday will fix the matter. It will only come for written argument.
Yes,
nothing.
yes.
It will come as a parted matter, just to take the written.
I'll submit
argument.
it before that.
No, you submit it on,
My colleague, someone would be there from the state.
let somebody do it here, but I'll post it again on Monday,
My lord,
just for that purpose.
I'll do that, my lord.
Yes. Because you have
If-
both made pretty witty and elaborate
lord,
arguments. In a way, kind of trying to give a fresh lease of life to the controversy which was apparently resolved earlier. But anyway, since arguments have been advanced, the court has to deal with it. That's it.
Deeply.
But the records will retain.
Yeah, yes, of course, Lordship. That was the idea. We were
Deeply.
carrying it only for that. Lordship,
Hmm.
I'm not getting into the judgments because they have all been considered and I'll be only reading all of them. It's repetitive and we would be just burdening Lordship's time. So Lordship, 10 sentences, as I said, and I will put them in my written submission. Number one, I said at the start of my arguments, the event or the defining event is the determinative entity is the entry, the determinative factor. That's it. He, the petitioner here, Lordship, is identically placed up to that determinative event, which is the tainted entry.
Mr. Kohli, if I may just interrupt you
Of course.
for a minute. Those aspects, there is no controversy, there is no dispute.
I'm coming, I'm building it, Lordship.
There is only one issue which requires a very close look. And therefore, the arguments now can only remain confined to that. The issue is, what was the basis for the authorities to discharge? Was it an order of discharge or dismissal?
Dismissal.
If it was
Discharge.
police report, then what would be the effect? Because there are conclusive observations made in the record that he is guilty of committing fraud. So to that extent, how can the departmental authority come to that conclusion merely on the basis of police report? Police report may ultimately play a role. But so therefore.
My argument is on that, but I'm
Yes.
building it because they are all interlinked, Lordship.
Okay,
It's not, it cannot be answered
Okay, we
otherwise.
don't want to disturb you.
So Lordship is the three, again, I'm going back. Why I say Lordship, because everything that flows from this only. Each one is like it's like a domino effect, if I may call it,
Yes,
Lordship.
yes.
We need to build that argument. It's a foundation over which another one. The determinative factor is the tainted entry. When the scam comes, police records an FIR, does an investigation. He is no different place. He has an allegation of paying up for a bribe. No different place. He is also charge sheeted, no difference. He was also arrested, which the file will reveal. That is why I wish Lordship to see the file, because the first part of the notings from 2019, June, if I recall, Lordship, show all the newspaper cuttings. It's identically placed. There is no difference. That entire procedure of whether a police report can be the foundation or not has been considered in Krishna Yadav and Chakradhar. Among the various judgments, they rely on Khatri, which is why I said para 9, 46, 48. So that cannot be the basis of a new argument respectfully, because that has been in detail over several days argued. And that is clearly what the court also holds, that this court says it's a thorough investigation. Otherwise, why would there be a charge sheet? In this case, Somebody goes and exchanges a number, answer sheet, somebody goes ahead and changes the numbers. So, but the scam and the entry is tainted is on a group who are identified. So again, pausing back for a minute, Supreme Court is clear, if there is an exercise of any nature that segregates the tainted from the non-tainted, the tainted have to go, the examination does not go. So respectfully, that's the first leg. He is tainted, his entry is tainted. He is identically placed as everyone else up to the point of entry. So the argument, which is the next, of the applicability of service conditions and rules and 311 cannot apply, will not apply. This is the line. Everything after that cannot be, because the foundation, and Lordship, there are judgments to that. If the foundation goes, the superstructure goes. And then there is the theory of useless formality, that if the outcome is to be identical, you do not need to go into audi alteram partem. It's not required for useless formality. That's the first point. Second, Lordship, in his case, the only difference, if at all, is after his entry, the issuance of a show cause notice. That I'm saying is the only difference. It doesn't change the factum or the factor of his entry being questionable as identically to 52 other petitioners on whom there's a judgment and no stay by the deed. No change with that. Next, Lordship, not one of the citations of the learned senior advocate is on a malafide entry. Each one of those certain judgments are on a bona fide entry. Palak Modi, Khatri, or even Gujarat Tubes, all dealt with. They all deal with permanent employees. So next factor, he is a temporary employee who has been discharged under the rules. As many others, there were 3 exceptions who had stigmatic things. That also the learned single judge has felt it does not apply. Not one case on this. Third, Lordship, these are all different legs. What are we talking about? We are talking about public office. We are talking about public servant, public interest, and public trust. The state, keeping these 4, public office, public servant, public interest, public trust, is obligated to act to restore faith in a system that came under challenge. It is obligated, and second obligation has to act equally for equally placed persons. Again, back to the entry point. The inequality that can be sort of created is the facts in his case. And I use the word miraculously, which is what we told the secretary when she came to my office the first time. Miraculous. We are arguing the whole batch. He's quoting Ajay Chaudhary in another quote. Now we said, let's not go into that. Let's understand he's identically placed. That's our determinative factor. Next, Lordship, come to the writ jurisdiction. He has approached the writ jurisdiction or this honorable court, Lordship. And respectfully, the question I have to ask myself is, what public interest is to be served by his reinstatement into public office? It's the writ jurisdiction cannot be to serve his personal interest. This is because it's a magnanimous, it has to be based on equity, Lordship. So that indulgent. And second, respectfully, I ask myself, Lordship, with fear also, what does his assumed reinstatement do to the entire exercise, including the judicial intervention at the CBI case, scrap the whole process down to the detailed adjudication that took place over several months and almost a year. So again, I ask myself the impact, what is the interest to be served? And 2, the impact. Next, Lordship, without prejudice, his own response to the show cause notice smacks of malafide. What is his response? His response is not.
Let us see, it is there in the record.
Yes, Lordship. We may come back to his petition, Lordship. It's right here
Yes.
in my file, in my briefcase. And if I recall, Lordship, it's at 75. Yes, Lord. No, bail order. The response is, Lordship, at 112. We must read that, Lordship. And now I shall read it, Lordship. I wish Lordship to come to 114.
Yes.
I will now read 5 paragraphs. Because so far I've skipped through it and just kept it. On 114, Lordship, para 4.
Yes, please.
That in the contextual facts to the APSC cash for job scam. So he himself is saying, contextual facts of the APSC job cash for job, I beg to state 1A, that it is needless to say that all employees under the government of Assam are uniformly covered by the Assam Rule 64. In other words, the government of Assam being the employer of its employees. Lordship, he doesn't say I'm a temporary probationer. He is now treating himself as a valid appointment who is confirmed. Irrespective of the departments, comes under the purview of one uniform yardstick in the matter of disciplinary proceedings. Now, one of the accused in the alleged scam, Nabakanta Patel, who was in judicial custody beyond 48 hours, was also departmentally proceeded by the government. And next line, Lordship, below all that is, has been pleased to reinstate Nabakanta Patel in service. Pause. So now Nabakanta Patel is not a beneficiary or an accused in the recruitment. He was a tout. That means valid entry, misconduct while discharge of his duties. Unlike him, no valid entry and no misconduct during discharge of his duties. So he invokes Article 14 selectively. Is this equity, Lordship? Is this disclosure? Let's turn the page. That apart from the above, another accused in the alleged scam, namely Syed Mosharraf Hussain, stayed in judicial custody beyond 48 hours, has been reinstated. Syed Mosharraf Hussain is an employee of the APSC. Again, valid entry, misconduct during discharge. He cannot be dismissed or discharged from this. Then let's go next paragraph, Lordship. Para C. That considering the fact I am also a government servant, nowhere probationer, nowhere temporary, on which Rule 21 will apply, under the same government of Assam, who has taken into custody on mere suspicion, your good office may be pleased to treat me similarly with the above named accused person's government servant by bestowing the similar relief. So he now, and I would say intelligently, divorces himself from the group to which he belongs to a group to which he doesn't belong, which is validly appointed permanent employees of the government. Next paragraph, Lordship. That alternatively, that if I fail, I humbly pray to keep the present proceeding in abeyance, as the charges leveled, including the materials relied upon against me, are identical with the charges in the criminal proceedings, and as such that if I disclose my defense in the proceeding, the same will cause prejudice to me in the criminal trial. Pause for a minute. That is how 52 other petitioners who are similarly discharged are. What is the difference between the two? Lordship may not just read this with page 89. Lordship, 89 was the bail order which starts at 85. Lordship, I beg your pardon. 85, Lordship may come to. Lordship may come to 85. This is the order of this Honorable Court of 28/11/2019. Lordship, this was a little different. And para 3 and 6, Lordship, are the facts. One of the unsuccessful candidates in the selection for the said post of Agricultural Development Officer lodged an FIR before this. So that's the background. Para 6, Lordship. Para 5. That the petitioner on 5/8/19 submitted an application before the authorities in the Agricultural Department of the state for granting him subsistence allowances through the Director of Agriculture. 6. As in the meantime, 90 days had elapsed to place the petitioner under suspension from service and the authorities of the Agriculture Department of the state as required under law without reviewing kept the petitioner under suspension. The petitioner filed this writ petition stating that such action of the respondents have caused him grave and serious prejudice. So he invokes lordship, the ratio of Ajay Chaudhary. Ajay Chaudhary relates to lordship a validly appointed person. Now let's come to para 18. The reason I came to this order was para 18, which has to be read with the show cause notice, para 5, his reply. However, it is made clear that the respondent's department may initiate the disciplinary proceeding against the petitioner in accordance with law and to complete the same at an early date, with the further observation that the petitioner shall participate in the same towards its early completion. He holds my argument without prejudice that this is all should not have taken place. The fact of the matter is, comes to the writ court without full disclosure, on equity, gets an order with a direction that please comply, goes back to the department and then says keep it in abeyance. Is this equity, lordship, I ask myself? And why should the state have someone in whom the public will have no trust? The public will always look at mistrust and keep him as a permanent employee at the cost of public funds. That to a temporary employee. Then, lordship, what they are arguing, and these are my last 2 points, is, I said none of the judgments apply to the facts of this case. They are for a valid appointment. Now, what we are expected, lordship, is let us read into a simpliciter discharge. So my next point comes, for an identically placed person, that same discharge has been considered. Even discharges that I would hold personally, lordship, that they could be into the realm of being stigmatic discharges. Those also have been upheld, which is why I showed those 3. So read into it that there is somewhere something that is going beyond the police report. I'm saying the file will reveal his arrest and suspension is based on exactly the same principles. And how can 311 and misconduct and all the arguments related to that fall for him? And last, lordship, how can, or rather I say, I find it, lordship, I ask myself, there is an attempt to distinguish a detailed adjudication by this court by saying this is separate for a person who's also a beneficiary or tainted in the same scam. But how is it that this argument can be said that 3 judgments, a sentence here and a sentence there, for validly appointed persons will apply to a case like this? That's the crux of my argument, lordship. I'm so obliged for that. And lordship, on Monday, we have to give our written submissions about 3-4 pages, lordship. Less? 2?
That is your discussion. But what I would request to Mr. Kohli,
lordship,
this distinction part that you're saying, the other judgment, facts in the other judgment in this case, if you could please highlight that.
I will.
And the similarities, you can also do it in your judgment, and a brief reference to the paragraph numbers of the decisions.
So what I shall do, lordship, I will, I know what I have argued, I've taken notes. So I'll give lordship that distinguishing what I said, para 9, this, etc. And what I will also do, lordship, is the judgments that we relied at the SG, though they may not have been dealt in that manner, and the principles we did, I'll give it as a judgment thing. These were considered, these are the paras. Should lordship feel the need to wish to visit them?
Absolutely.
I'm so obliged, lordship.
You can also do that.
Yes.
Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. J. Patwari, appearing for the writ petitioner, has addressed argument. And Mr. N. Kohli, Learned Senior.
Nimisha Menon.
Assisted by Ms. Nimisha Menon, has also addressed arguments on the merit of the writ petition in order to give the learned counsel for both the parties to make further submissions and also present written note on their arguments. This matter is directed to be listed again on 5/6/2023 as a fixed part heard matter. But it will be only for taking the arguments.
Yes, Lordship. I will be sending it through a colleague.
Yes, written arguments, only that. And will you please make a note of these decisions and the soft copies? But there are some very interesting points here, which I would like to go through in a little detail to understand how the law has evolved.
No, Lordship, we are obliged for that because this also has tested us in terms of revisiting it and looking, and that's how we came up with
Yes,
that other
and the
judgment.
biggest thing is, despite there being a elaborate judgment by the learned single judge on the more or less the same facts, this matter almost
Has
was
taken
heard more
3
than
days,
2
Lordship.
years.
Lordship is retaining the records. Your Lordship
Yes,
is-
the records submitted
Thank
by the learned department council be retained by the court master. in safe
Deeply
custody.
obliged, deeply
Right. Leave it up there. Is that all?
Before I start, My Lordship, my senior is appealing for the private respondents in item number 7, 8, 9, and 10. He just he conducted a very detailed hearing for this court, Your Lordship. He is not here as of now.
I can call.
Okay, or we can start the.
Yeah, but I will not adjourn it.
No.
If all parties are ready to argue, then only. How long will you take?
This is effectively one matter, Your Lordship. Item number 10. It takes into account all the facts, starting from item number 6. Item number 6 was a 2013 matter. Item number 10 encompasses all the facts. So for Your Lordship's purposes, it's actually one matter, Your Lordship.
All right. Please give me the file of item 10.
Item number 10, Your Lordship, WPC 1148 of 2021.
Yes.
Yes. Your Lordship, will kindly come to page number 19. Yes. Page 19, Your Lordship. Page 19 is an advertisement loaded by the APSC for 18 stipendiary posts for the year 1989 to 1991 in the Forest Department. For 18 posts, Your Lordship.
Yes.
Thereafter, Your Lordship, there was a recommendation of 44 candidates for those 18 posts, which is at page 31 and 32. The advertisement culminated, Your Lordship.
Just a minute.
Yes, Your Lordship.
Yes.
Your Lordship will also see in the first paragraph of the advertisement
Mhm.
that there is a reference made to the Eastern Forest Rangers College, Kurseong. And the
Yes.
course is scheduled to start or to commence from the 1st of May 1989. That will be relevant at a later point in time, Your Lordship. Thereafter, if Your Lordship comes to page number 31, which is Annexure B, there's a recommendation of 44 candidates for interview. Your Lordship, the petitioner's name features at serial number 6 and serial number 2.
How many petitioners are there? Two.
There are 2 petitioners, Your Lordship. Subsequently, Your Lordship, there's a select list of the selected candidates which was published by the APSC, which is at page 33. Page 33, Your Lordship.
One minute.
Your Lordship has page 33, Your Lordship.
Yes. Petitioner number 1's name features at serial number 5. Your lordship would see that. Serial number 5. Petitioner number 2's name features at serial number 9. Your lordship has that.
Just a minute.
Yes, yes.
Good to listen, lead.
You're in page 31.
Page 33 now, your lordship. At page 33 now. This is pursuant to the recommendation of 44 candidates, the final select list of 18 candidates, your lordship. 1148.
Yes.
Petitioner number 1's name features at serial number 5.
Yes.
Petitioner number 2's name features under serial number 9. Thereafter, your lordship would see respondent number 7 and respondent number 8's name do not feature.
Who are the respondent?
Ashok Dev Chaudhary and Mustafa Ali Ahmed, your lordship. Respondent number 7 and respondent number 8. Their names are not in this list, your lordship. Respondent number 9 and 10, however, your lordship, their name features under serial number 3 and 13 respectively. There's another pertinent aspect in the matter, your lordship. Page 33, the first line, it says, pending finalization of draft service rule. This order was passed in 1989. As of now, the draft service rules are still at the draft stage. There are no draft service rules for the forest government, your lordship, as of now. Thereafter, out of the 44 candidates, since there were selected candidates of 18, the rest of the candidates, your lordship, preferred a representation, which is at page 38. Page 38, your lordship. If I may read the representation, your lordship. Page 38 is the typed copy. Page 38 is the typed copy. If I may be permitted to read, your lordship. To the Secretary of the Government of Assam, Department of Forest, subject prayer for full absorption of APS's list of selected candidates for Rangers course in Forestry 1989 to 1991. We, the undersigned applicants, most humbly and respectfully beg to state that after facing stiff competition and undergoing rigorous selection process of written test, physical fitness test of long walking in sun and showers, exhaustive oral interview held by the APSC for selection of candidates for Rangers course in Forestry 1989-91, we have secured the selection in the list of 44 names recommended by the APC, wide letter number so-and-so. We are all educated, unemployed, local youth of Assam belonging to different caste and creed and coming from different parts of it. We're all interested to serve the forest department of the state, and that is why we have boldly faced and overcome the rigorous process of selection. We understand that the forest department has now more than 100 vacancies of rangers post against which the department can very well absorb the 44 number of candidates, recommended candidates of the aforesaid APSC's list. It may not be out of place to mention here in the last year, all the 44 number of recommended candidates were absorbed. Many of us may not have the scope of fulfilling our hopes and aspiration of being absorbed in the said post because of age and other factors if we are not absorbed from the current list, and in such case, we shall have no other alternative than to face frustration. We therefore earnestly hope and pray that for doing justice to the selected educated unemployed local youth candidates, Government of Assam may be pleased to absorb all the selected 44 candidates of the aforesaid APSC's list against the existing vacancies of rangers posts in the department, as can be possibly no better scheme for employing suitable local educated unemployed youth. Your lordship would see the signatory, respondent number 7 and respondent number 8 figure in the list of signatories. This is after the select list by the APC was published, selecting 18 candidates. What may also be relevant for your lordship to note here is that pursuant to the selection of the 18 candidates, if your lordship can kindly come to page 37 for a moment, page 37. I request lordship to go back, page 37. All of those selected candidates, your lordship, were also posted in various subdivisions within the state of Assam. The reason.
So
be-
this is for appointment of forest rangers.
Yes, forest rangers. What has happened?
So can you please tell me in a nutshell, what is this
What
whole?
the issue here, your lordship, there are
Yes.
two issues for your lordship to ponder. Your lordship, firstly, the APSC had prepared a merit list on the order of preference. The first question that arises before this court in this matter is that whether the order of preference which was published by the APSC in its merit list needs to be followed for matters of promotion subsequent thereto. That is the first issue. The second issue that arises before this court is that outsiders who were not selected pursuant to the process and who were inducted by a parallel process not sanctioned by the APSC, can they claim legitimacy over the inductees or the candidates over and above the normal selection? That is what has happened. In fact, your lordship, till 2005, there are certain very prominent events here that have happened.
So according to you, this respond number 7 and 8,
Yes,
their entry into service is not through a legitimate process.
it's not through a legitimate process,
Not in accordance with rules.
not in accordance with the rule.
Therefore, they should not get seniority.
They should not get seniority. In fact, item number 6 before your lordship, item number 6 was occasioned when there was a promotional, that is a part of item number 10 also, if your lordship can kindly see.
So all the writ petitions, same petition.
All the writ petitions are similar follow-ups of item number 6. What has happened eventually, your lordship, is that in item number 6, we had challenged the promotion from Ranger to ACF of the private respondents who were firstly ranked lower or who were outsiders of the list of 18 candidates. Subsequently, there was no stay granted by this honorable court. In 2020, your lordship, there was a notification which stated that the order of seniority will be as per the APSC merit list. We filed a writ petition stating that the OM should be implemented. There was a positive order to that effect from this honorable court. Thereafter, that OM was kept in abeyance. And subsequently, the further set of writ petitions took place, where now the private respondents, your lordship, being outsiders and being below the merit list, are a post higher than the petitioners.
So this is promotion from which post to which post?
The promotion initially started from the post of Ranger, Forest Ranger to ACF, and thereafter to DFO.
So now the petitioners are.
Our
holding-
ACF, we are ACF now. We have been recorded one instance of promotion. The private respondents have jumped 2 ranks. They are now DFOs.
So where is the gradation list of ACF?
There is one gradation list, your
Where is
lordship.
it?
Yes. Your lordship can kindly come to page 44, your lordship. This was the initial gradation list of forest rangers. Page 44. In page 44, lordship has that?
Yes.
Yes. Petition number 1's name features at 146, serial number 146.
That would be in page number.
Page, give me a moment, I'll just, page number. 146 will be page number 58, your lordship. 146,
Page number 58.
58, your lordship, page 58, serial number 146.
So that is 146 is petitioner number 1.
1.
And where is the other?
Petition number 2 is at 150.
150.
150.
So this is the gradation list of
Forest Rangers.
ACF.
Yes.
Forest Ranger.
Forest Rangers. There is no subsequent gradation list of ACF which have been published, your lordship. All promotions, subsequent promotions have been sought to have been.
No gradation list of ACF.
My lord. My lord,
No gradation list of ACF. till
there has
today.
to be one.
Where
There
is
is
it?
one. It is not the next year, my lord, there has to be one. And my lord,
Oh, has to be. Show it to the court. Where is it?
as of now, my lord, I don't have it, ma'am. There has to be one. Because issue is, my lord, something different.
Issue, what
It's
my
traversing
understanding has
different-
said is not the issue. I know what had happened when this recruitment took place. In the appointment order, it was clearly indicated that merely because somebody's name appears in the APSC list, it does not mean, my lord, he is recruited to this service, because there was a requirement of passing 2 years training. And my lord, in the appointment order itself, it is clearly indicated that only on successful completion of training, that too on the basis of the merit list published by the training institute, seniority will be fixed. My lord, that was with that condition they joined the service. I do not know. Please come to, my lord, this order.
That's fine.
Yes.
You may be correct on that. But there can't be a promotion to the post of DFO without the.
No,
gradation list.
there, why not? There is.
Where is the ACF?
Only thing is, my lord, there is an order of this honorable court from time to time in different proceeding that it will not be finalized, or even if any seniority list is published, it will subject to the outcome of the proceedings pending in this court.
Mr. Sharma, is there a gradation list of ACF? You say no, he says
No,
yes.
we are not aware. In fact, we have sought instructions
There
from the
has
client
to be.
specifically to that effect, Your Lordship.
Where is it?
My lord, once your lordship decides the issue, whether seniority will be based on APSC list or on the training list, because Assam Forest
We will
Regulation.
not decide anything. We'll only say
Ah.
if there is no gradation list,
Ah.
then they have to first take out, circulate a provisional gradation list. And thereafter, once the gradation list is finalized.
No, my lord, that issue would remain, my lord.
Which issue?
The issue, the senior, who would rank senior? The one whose
Let the
name.
department decide that first. Let the department decide that first. If they are agreed with that and challenge it, then we'll see.
No, my lord, we have challenged an order.
Which one?
In one writ petition, that is, my lord, WPC number 4942 of 2020, where they had taken a stand that it will be on the basis of APSC list. That is what we have challenged. And there is.
No, Mr. Chaudhary, it will be like this, it will be like that is one thing. But where is it? Is it there or not?
It is there. They have
Where
taken-
is it?
Yes, I'm coming. I'll
Where
show
is
you.
the gradation list?
No, no. Before gradation list, my lord, let us first find out who will rank senior in what, based on what criteria. Whether somebody's name appearing in the APSC list or somebody's name appearing in the training list. That is the basic issue, my lord. That's why all these litigations.
Therefore, unless the court knows whether there is a gradation list of ACF and what is the position
No,
there.
I think there is a gradation list of ACF,
No,
but that could not have been finalized because of this pendency of these proceedings. That is why the promotions have been affected.
The departmental council is not sure.
Right, we can have it.
There has to be one. Well, it
Show
is
it,
not
give
here.
it, give it, give it, pass it over.
No, not now. I don't hold it now.
No, has to be, don't make these arguments. Where is the ACF? If it is there, give it. If you can't give it, it is not there.
But it is not with me now because it is their petition. I have not filed anything now.
No, without ascertaining that, I'm not embarking on any adjudication here.
In that case, my lord, I'll seek leave, my lord. I have to produce that. I have to seek instructions and produce it.
When will you produce?
I can produce it by next week. ma'am. I can produce it by next week, bring it on record, man.
We will.
My lord, just for a moment, my lord, if your lordship would kindly come to page 19 of the writ petition, which my learned friend was referring, please see, my lord. This is of 28th of February 89. Precisely, we are concerned with this selection. Kindly see the heading, my lord, Assam Public Service Commission, Rangers course in forestry. Then, my lord, will kindly come to page number 28. 16A, 16C. On successful completion of 2 years course at Karsiang, the student will be awarded by the college authority either higher standard certificate in forestry or lower standard certificate in forestry and will return to Assam to join duty. Those students who are awarded the higher standard certificate in forestry will be appointed as forest ranger in the scale of pay of rupees so and so, and those who are awarded lower standard in forestry will be appointed as deputy ranger in the scale of pay. This was the advertisement, my lord. And they failed. One of them failed, one of them secured lesser marks.
So where is the list of the forest school? This is the.
Yes, I'll show
Where is
that.
list?
That I'll show, my lord. Now, my lord will kindly take this item number 4942.
So, Mr. Sharma, I will hear you.
Yes,
Don't
yes,
worry.
yes.
I'm just trying to preliminary.
Yes, yes. My lord will kindly come to 4942 to the person.
Yes.
Please come to page 50.
Yes.
My lord, this is the formal order of merit. Kindly see, my lord, serial number 10, that is Dibakar Bora. Oh, sorry, yes, serial number 2, my lord, Dibakar Bora, he is petitioner number 2 in our case. Then, my lord, 35 is and serial number 3 is Ashok Dev Chaudhary, he is petitioner number 1. Then serial number 5, Konok Boisha is petitioner number 4. Kindly see the mark we have secured. Mustafa Ali Ahmed, his petitioner number 3. So these are the 4 petitioners. Kindly see, my lord, serial number down below 4016, Sadadat Ali 7. He got, my lord, 59.48%. Lower mark. Utilization only 44.33. And the other gentlemen, subjects failed, but they failed in a particular subject. Then please come to page 51, serial number 34, Kukhol Deka, 52.46. He failed in 3 subjects. And, my lord, there is a Supreme Court judgment, my lord, which is, it is covered by that. It says, my lord, who gets higher standard, he will rank senior, and those who gets lower standard, he will be appointed as deputy ranger.
Which is the judgment?
Yes.
Have you seen the judgment?
Yes, I placed it on other earlier occasion. 2010 4 SCC 301. My lord will kindly come to paragraph 2. The recruitment to the post of ranger in subordinate forest service is governed by a ranger subordinate forest service recruitment rule 69, which were framed by the government of Gujarat in exercise of its power, conferred under proviso to Article 309. My lord, in the state of Gujarat, there is a rule. In our state, there is no rule. There is a draft rule, but there is an order of under the old forest regulation. Now, kindly see, my lord, para 5. Rule 11 says that state government would bear the cost for the training, and during the period of training, the candidate shall receive stipend, emoluments, and other allowances, if any, as fixed by the government from time to time. Rule 13 deals with appointment. Rule reads as follows. On successful completion of training course for the Rangers course college, the candidate shall be appointed as a ranger if he passes with the higher standard certificate, and as a forester if he passes with lower standard certificate. Now, my lord, as far as our state is concerned, my lord, we are having my lord, this is a part of the Assam Forest Manual. Please come to the second page, my lord. Numerical for appointment. Kindly see, my lord, on the page 12. Subordinate forest service comprises of ranger, deputy ranger, forester, guardians, etc. Rangers. Conservator may appoint the following to the class of rangers. Candidate who obtain honors or higher standard certificate after 2 years training at forest college, then it was only Dehradun. Deputy ranger who have obtained lower standard at the forest college, who have rendered not less than so and so. So Assam is following this rule, mind. And the rule which was considered by the Honorable Supreme Court is at para 5, which I have just now read. Then my lord will kindly come to paragraph 36 of the judgment. 37. 36 and 37. The Undersecretary of the Forest,
Yes.
Undersecretary of the Forest and Environment Department had, however, put up a note on 29/9/2093, evidently under pressure from the candidate of 79 and 81 batch, misinterpreting Rule 14 of the 69 rule, stating that candidates of 79-81 batch should be placed above the candidate of 80 and 81 batch. Rule 14 of the 69 rule determines the inter-seniority of candidates of a particular batch and does not determine the inter-seniority between two batches, whose educational qualification, year of training,
and date of joining, etc. differ. Rule 14 of the 69 rule and Rule 22 of the 74 rules also further re-emphasize the fact the note put up by the Undersecretary on so-and-so is therefore contrary to Rule 14 and Rule 22 of the rules. The 1969, 74 and 79 rule clearly stipulated how seniority has to be reckoned. Rule 14 of the 69 rule and 22 of the rules are in perimetria, which state that seniority of the rangers will be governed by their respective ranks in the examination of the Rangers College, irrespective of their joining service on successful completion of training course of the candidate, shall be appointed as rangers if they pass with higher standard study. So, my lord, their date of selection is irrelevant. So now
So
they.
according to you, your clients rank higher in merit.
Yes. It's a fact, my lord. In the APSC list, their names were above us. But in the select list prepared by the college, my lord, after the training, we were much above him.
So what is there?
So that is the case.
Yes.
What is
Your
there
Lordship.
to be decided in
Yes,
this?
Your Lordship, my senior has referred to clause 16C of the advertisement, Your Lordship, which reads that on successful completion of 2 years course at Kurseong, the student will be awarded by the college authorities either the highest standard certificate in forestry or the lowest standard certificate in forestry, and will return to Assam to join duty. Those students who are awarded the higher so-and-so, Your Lordship, this clause is not applicable in the present case, even though it's a part of the advertisement, Your Lordship, because it should be applicable and confined to those 18 candidates who were selected. Those 44 candidates.
What do you have to say on the Supreme Court judgment?
That will not be applicable in the present case, Your Lordship. In this present case, Your Lordship, the matter is between selected candidates through the APSC and candidates who have been selected by a different process, who should not have been in the process in the course at all. The course in Kurseong Eastern Forest Rangers College in Kurseong did not materialize. And prior to that, the 18 candidates were deputed in service, while the private respondent number 7 and 8, were not even in service, Your Lordship. They had not even preferred their application while we were already deputed in in-service training. The list of 18 candidates does not contain respondent number 7 and 8.
So where is your list of dates and synopsis for all the cases?
Yes, Lordship, I provided a copy. There's a copy again.
Covering all the cases you prepared?
Covering the last case, Your Lordship. It's a document reference.
No, but I need to know who is the petitioner in other cases. Otherwise,
7, 9 and 10 are the same petitioners filed by my client, Your Lordship. Respondent numbers, item number 6, there's one petitioner who's unfortunately expired given dependency.
yes, but then are you not required to make a
we will
composite?
prepare a written argument if need be, Your Lordship. Or
Not written argument, a composite list
Yes,
of days, what
yes.
exactly is the case?
I can prepare that.
Why do you say it is not covered by this case?
Your Lordship, the aspect of the advertisement, my humble submission before this court, Your Lordship, that the entire terms and conditions of the advertisement has to be confined to those who have been selected pursuant to the process. Here, the matter of state of UP versus Rakipuddin will come into effect, where munsifs were appointed in 1970. Thereafter, the lowering of marks was done by a high-level committee, which is Honorable Supreme Court stated that they cannot do that. That is my only submission before this court, that had the ranking in the university or the college happened within and amongst those 18 candidates, I may not have had a case before this court. But now what has happened is there are candidates who have not been appointed, who are not selected. Whereas I was appointed prior in time. I was deputed to be in service. When Kurseong did not accept my candidature, and thereafter Jalukbari College started, it is then that the private respondents had entered the process by a parallel process. They cannot be equated with my standing. That is my submission. When the process culminated with the selection of 18 candidates, the process ended there. The select list was published by the APSC. The advertisement was conducted by the APSC. I was deputed in in-service training in the subdivisions, even before the private respondent stepped foot inside the department. Thereafter, they stepped inside. And the first.
So you tell us, Mr. Gogoi, if there is a seniority list of ACF and produce it. We'll have it when? When can you do it?
By next week.
Give a date, then we'll have it on.
Well, that will be
20th.
next week on my lord.
20th, 16th.
16, my lord.
13th June.
15th,
15 June, 15 June.
15.
You make a consolidated note
will do,
on
will do,
who
will
is the
do.
petitioner in which case,
Yes,
what is
yes,
the relief.
yes, yes.
Because we have to dictate a judgment.
Yes, your
Mr. M. Sharma, I counsel for the writ petitioners in item
Item number 6, 7, 9, and 10.
6, 7, 9 and 10.
Yes, my
Is
select for-
Mr. K. N. Chaudhary, Learned Senior Counsel appearing for the petitioners.
In 8.
And item number
Eight,
8,
eight.
Mr. D. Gogoi, Learned Departmental Counsel is present. After hearing the submission of Learned Counsel for both the sides, this court is of the view that there is a need to ascertain whether the department has prepared any final gradation list of officers in the rank of SEF, and if so, produce the list for perusal by the court on the next day. And the request of Learned Counsel for all the side, this matter is directed to be listed again as fixed items on 15th of June 2023. You also go through this judgment.
Yes, yes, yes.
Yeah, what is the matter?
Well, this is
Sorry?
relating to my lord non-payment of service benefits, my lord. And also the order of termination is under challenge.
It will take some time.
It's likely, my lord, to take some time. Because,
Take some other date.
yes, my lord, but only thing, my lord, they have to produce, number of times they have failed to produce the records, man. That will be necessary, my lord. There is a specific order from this court.
Who is
Produce the record
who's
from-
supposed to produce the
From
record?
Karbi Anglom Authority.
23/11. Have you got the
23/11/22 order, my lord. 23, dated 23/11/22.
Lordship, the original record has been misplaced, Lordship. That is why we're taking some time, Lordship.
Then you file an affidavit.
Affidavit we have already filed, Lordship.
Or the custodian may be directed to be
Saying,
present. here.
saying that the record has been misplaced.
Lordship. Lordship,
At one point of time, they had said records are with them and it was here, but the matter couldn't be
Lordship,
taken up.
This has been communicated to us.
I heard Mr. B.D. Goswami, Learned Counsel appearing for the petitioner. Also heard Ms. S. Kemprai, Learned Counsel appearing for the KAC. Mr. A. Hassan is present on behalf of the
Accountant
General. Accountant General Hassan. By referring to order dated 29/11/2022 passed by this court, Mr. Goswami submits that records will be necessary for final hearing of this writ petition. However, Ms. Kemprai has prayed for some more time to produce the record by urging that the same has been displaced in the office. On the request of Ms. S. Kemprai, Learned Standing Counsel KSC, this matter is directed to be listed again on when
Date may a date may convenient, but on short, I would pray for a shorter date.
15th of June.
My lord.
Lordship.
Much of